Right. Good morning, everyone. We do have students here today, so attorneys, if you get the opportunity, they're from the Criminal Justice Department at Texas State, and you have some ideas to tell them, please share with them. They are here to learn. I'm glad you all are here. It's good to see you, and I hope you find out more about our court and legal system today. All right, what I'm going to do is call the docket. If you are here, please stand so that we can identify you. And attorneys, if you have a short announcement, please make that. Otherwise, we'll come up and approach the bench. Jarden Coons. Jarden Coons.
He's here, Judge. He's in the back row.
Okay. Do we have an interpreter for him?
No, we do not.
Okay. We'll approach on his case. And his attorney, was he going to be able to be here?
He is. He's not going to be here until after 10.
Okay. Rosalie Cortez. Kimberly Destin.
President Counsel, Your Honor, we're still waiting for discovery in the case, so we're going to pre-trial.
Okay, come on up. You can be first to approach. Let us get through the calling of the docket. Jose Duran. Elijah Ellaby.
I'm here on that, Judge. He's in custody. This is our first pretrial. I got an offer. I'd like to have one more pretrial on this.
Okay, let's go ahead and get him on his way up so we can just tell him what we're going to do on his case.
Yes, sir.
Lazaro Gonzalez Espinosa. Manuel Granados.
Your Honor, he's in custody. We did get those medical records yesterday
Oh, good.
after your enticement. It was conveyed by the state. But
Just that you were considering, not that you were doing.
Okay.
right. But if you could bring him up, because I think there's a disparity in the records, I want to discuss that with the board.
Okay.
And why we're gonna have to do a subsequent subpoena directly to him.
Very good. Let's do Granados after that. Okay. Anya Hart.
Good morning, Your Honor.
Good morning.
I'm present on that. As far as the defense is concerned, we're probably going to put about 10 minutes worth of testimony on whenever it faces the court.
Okay. Do you have other business in here?
Yes.
Okay. Edward Hernandez. Frank Hernandez. Thank you, sir. Pierre Hill. Patrick Jones. Thank you, sir. Have you seen your attorney?
My counsel's in that.
En route. Okay. Garen Magistro.
President Counsel, Your Honor, your case is on recall.
I will.
Thank you.
Mark y'all conferring. Thank you both. Roman McKimmid.
You're also President Counsel, Your Honor.
I'll mark y'all conferring. Thank you both. Robin Medina. Alexander Mikhailowicz.
President Counsel, Your Honor. We were ready like the project.
Okay. I think let's do, unless there's someone here, we'll put you right after that first one.
Yes, sir.
Royce Miles.
President, ready.
Have you been able to review the report with your client?
There was no PSI on that one.
Oh,
It was just a delay for sentencing and incarceration, no PSI required or ordered.
great. So we just need to, he's here?
Affirmative imposition of sentence, that's all.
All right, let's do that one early too, because it's not going to take long. Get you on your way. Ignacio Munoz. Thank you, sir. Looking sharp. Muhammad Rajput. Nathaniel Ramirez.
President Counsel, Judge, will approach after this option.
Very good, thank you. Carlos Rubio.
Judge, she's texting me, it's gonna be a little bit late, at 9:20, she should be arriving. If the sentencing today, I'm not on the PSI, I'm just gonna go over the rights.
Okay, when he gets here, will you also, probation, get him to go get a test? Eric Sundin.
President Counsel, Your Honor, your case is on recall.
I will.
Thank you.
Paul Tompkins.
Judge, I'm here for that one. We filed a motion to withdraw.
Yeah, and the idea was that we were hoping he'd be here and then you would be here long enough to do the sentencing. And the court really appreciates that. Thank you very much. Let's give him a few more minutes to see if he's going to be here. Thank you. Brandon Vasquez.
Just that case was transferred to a different court yesterday afternoon.
Very good. It was transferred.
Yes, to the 22nd District Court.
Miles Williams.
Present with counsel, Judge, I anticipate that being Tuesday.
Okay, y'all let me know when you're ready.
Thank you.
William Baker.
Your Honor, I'm present on that. Mr. Baker's incarcerated. I have a brief order for your approval, but we'll probably need to get Mr. Baker up here.
Okay, let's do that. Just keep me, after we've taken care of a few things, let me know. Thank you.
Yes.
All right, we'll do jury docket now. It's a short jury docket, but I'd like to hear state's readiness and from defense as well. Jacob Kreitzer. Thank you, Mr. Kreitzer. Lincoln Pearson.
We are ready on that, Judge.
State?
State is ready as well.
Okay. State, how long do you expect you need to try this case?
I would anticipate 3 days for guilt innocence and an additional day if they're going to the jury for punishment.
Judge or jury?
I have to clarify with the counsel, Judge.
Okay, let me know, please. Thank you both. That is a 20 case, so it is the oldest case on the docket. Roberto Rangel. Thank you, Mr. Rangel. Have you seen your attorney? Thank you. Mario Stafford.
Your Honor, upon his present, he's on his way to the court. I think he went to the wrong one. We're ready.
Okay.
We'd like to clarify one issue with the state beforehand, and we're gonna go to the jury function.
State, how long do you need to try this one?
I would anticipate 2.5 days.
Thank you. And jury, y'all confer, and after you've conferred, let me know and approach, and we'll just.
Just an issue about evidence. I talked to Mr. Cooper about.
Yeah, not a problem at all. I want y'all talking.
There's my client, Judge, sorry.
Okay. Thank you, sir. Cade Tucker.
President Counsel, Your Honor, we have a motion for continuance on file since the 3rd.
Okay, we'll come up and take a look at it. All right, you may continue conferring and we'll take these cases up. Let's is that your client there? Come on up, sir. Okay. All right, then we'll do Granados. Let me just take care of one of the inmate cases. Ms. Brown, can we do Granados?
Sure, absolutely. Mr. Bernardo?
Quiet, please.
All right, how are you doing today, sir? You kind of let me down today.
Really?
Well, I was expecting oh, it's a rose?
It's a rose.
Okay.
Made just for you.
Oh, well, you know, I'll maybe give it to one of the ladies, but that's very, that is impressive. I guess I couldn't see it.
You see it now?
All right, there we go. That's impressive. Did you know how to do these things or are you learning?
Learning.
All right, interesting.
Arts and crafts.
There we go. Well, good. It's something to
Keep your mind busy.
keep your mind busy. Good for you. All right. So yesterday we were here and we discussed that there was some pending medical records and state, you requested them, is that right?
We did. We followed up and we were able to obtain the records from WellPath that we had subpoenaed.
Okay. Did it take you having to threaten them in order to get the information?
I conveyed that the court was considering setting the case for a show cause so that the court could understand why WellPath had been unable to comply with a lawfully issued subpoena.
Right. Well, and I didn't mean like that part of the consideration, but I mean to get WellPath to hand things over to us. And that, I mean, the whole court system, is this what it takes? Is that
we have further investigated where the breakdown is occurring, and it appears to be at the corporate level at their legal department, which I believe is in Tennessee. Our local providers are timely assembling the records and sending them to their legal department. The legal department is not making a decision or stamping or reviewing those records. And in some cases, in this situation at least, did not even respond to our local providers, whether or not they were making a decision even on these records.
Right.
So that appears to be where the breakdown is. We're going to continue to work with them as needed to try and make sure that they understand their legal obligations and that it is important that those be addressed timely.
Great. If you need any support from the court, please let me know.
Much appreciated.
You all need to get them. You've needed them for a long time,
Correct.
and it's fair for you. And us waiting around for that information isn't appropriate.
Took Ms. Buse to do it.
Okay?
It took Ms. Buse to do it, and I appreciate it.
Yeah.
So I have a preliminary review of them, Your Honor, and I feel like there's some information lacking, things my client gave to me and showed to the court actually back in July. It was not contained in those records. So I'm curious as to what's going on. There's no documentation that is consistent with the document he showed us in court back in July. So I think I'm gonna do a subpoena to the jail for all of his just jail records and see if the jail told me that it shouldn't be in their records, it should be in the WellPath records. But if there's not even, when an inmate needs medical care, they do a request, whatever, those aren't in his medical records. So they're somewhere. So I've got to figure out where those are at. So I'm gonna do an overall blanket documentation request to the jail for everything. Because something's missing.
Okay.
We had a
When
document
can
showing.
you get that request in?
I can do that this week. The jail, I think, will probably respond, I hope timely, since they're local and the DA's office can hopefully caress that if need be.
Yeah, if you can. I mean, he's got a lot of days in jail.
Yes.
And us being held up because we're not getting information from them is, and
Right.
it's in the jail's best interest to timely turn it over.
Right.
If there's a valid subpoena. So
It's important too, Your Honor, because that's the information you've been asking us for, to have a reconsideration and a new appointment for a psych eval, for a competency eval, because we disagreed with what the findings were based on some additional medical information that my client has indicated exists. And that's what I'm looking for. Just didn't show up in WellPath. WellPath is just a digital outprint of stuff. It didn't even really show he'd been seen a lot, maybe like since January of 2024. That's why I have concerns. So,
okay. So what we'll do is get that request out this week.
Okay.
State, if you can help facilitate, that would be helpful. Let's get the shortest reset we can to come back and see what the status is. She'll tell you what that date is. I don't know what that will be. And then let's go ahead and set the next setting after that for a plea setting. So we're gonna have a status setting where we should have that information, but we're going to go ahead and get a plea setting on a state jail felony where someone's being held for
it's enhanced. It's not state jail felony.
state jail
It's 2
felony
to 20.
charge. Okay, well,
So you know.
right, I get it. No, I see the enhancements here. But the workup on a state jail felony, I get, then we have enhancements. And we're gonna give you the time to do what you need to do. We've got to start moving forward on that, is my thought. That's why we're gonna go ahead and set out after the status hearing. There's gonna be a plea setting. That won't mean, Mr. Granados, that you have to plead. It will just mean that if there's not a resolution, the next setting would be a trial setting. So what we're trying to do is give you an understanding of the timeline so that you know what's going on, because you have the right to know that. Understand? So then we're going to come back, we're going to have a status, we're going to find out if these documents have been turned over. Then the setting after that will be a plea setting. Okay, I'm not saying you have to plea, but if there's not some resolution, you just know that the setting after that will be a trial setting. That makes sense?
We'll talk about it.
Okay.
And then we're continuing to negotiate with the state collaterally, as a parallel path. All right, thank you, Judge.
All right, thank you very much. Thank you, State, for pulling that information.
It does look like he was transported to Christus on at least 2 separate occasions. So you may want to take another look at his records.
All right, who do we have here? Mr. Ellerby?
Yes, Your Honor.
There's more. I got the document.
Yeah.
Thank you. How you doing, sir? Is this your first time in court?
Yes.
All right, very good. All right, we're just here on a pretrial setting. Defense, do you have a offer?
Yes, we received an offer, Judge.
And do you have discovery?
I do have discovery, Your Honor.
Very good. What else do we need to go over?
That's it, Judge. I would like to have another, one more pretrial on this. Previous setting to this was the arraignment setting. And that'll give me a chance to review the material. I've gone through part of it, but I was a little slow for a couple of weeks. My back went out a couple of weeks ago.
No, you're doing okay?
Yeah, I'm doing much better now, but I missed a couple of days at the beginning of the month. And so I couldn't even stand up straight for a couple of days. And, yeah.
Well, so we're going to give you a little more time so your attorney can go through all that information and know everything about your case. Understand? All right, very good. Anything
Thank
else?
you. No, that's it, Judge.
All right, thank you. Thank you, sir. Yes, sir. Yes. And your client's name?
Kimberly Destin.
Destin? Ms. Destin, can you please approach? All right, so were you hired or were you?
Retained.
You
Yes,
retained.
this is my first court appearance.
Okay, very good. We had I'm going back over our records about, we had talked a lot of times about you needed to get an attorney.
Quiet, please.
And glad to see that you did. Thank you very much. That was one of the things I requested of you. All right, now that you're on the case, do you have an offer?
No, Your Honor, I do not. I do have most of the discovery.
What
I think they're
discovery do you
waiting.
not have?
Medical records.
We've subpoenaed but haven't received medical records yet, Judge, and we're waiting to make an offer until we've had an opportunity to review those records.
When do you expect to get those?
We should have them in any day now. And it is St. David's, it's not Wellpath, so.
Okay, all right, we'll do another pretrial setting on that and keep gathering information, make sure your attorney has everything in the case. Very good. Anything else?
Judge. That's it.
All right,
Thank you.
thank you. Thank you for being here. Thank you for being on time, Ms. Destin. How are you?
Good, are you?
Good.
Rubio arrived, Judge, you sit downstairs for the DUA.
Okay.
I'm sorry, I couldn't understand.
Mr. Rubio arrived and he's downstairs now, at the DUA.
Okay.
The
Very good.
other person I have is Nathaniel Ramirez, Judge. We've had a few pre-trials already. I was going to ask for one more.
Mr. Ramirez, can you come up? How you doing, Mr.
I'm
Ramirez?
doing better than last time.
You're doing better?
Yeah. than
Okay.
last time.
Yeah, good. Yeah, last time was
Yeah.
tough, and you were. Oh, yeah. You increase the bond in here, right?
Yes, Judge.
Okay. All right, I need you to go down and take a test for me. You knew that was gonna come,
Yeah,
right?
yeah, yeah.
Are you
one
gonna- are you
every
gonna be
week.
clean?
Yeah, I do one. I was clean last week with Sierra. I've been testing every week since.
Okay.
I got out.
Great, and you're with pretrial services, right?
Mhm.
Is someone from pretrial service, Lydia? Can we make sure that Mr. Ramirez gets a test, please? All right, well, good job, Mr. Ramirez. I'm proud of you.
I'll reapproach it when you.
Very good. Thank you. Paul Tompkins. Okay.
Yeah.
Huh? Yeah, I know. That's not a good sign. You need us? Or Allison? Pre-trial, are you, did she leave? Oh, she was left. Because pre-trial is assigned to Mr. Tompkins, right?
I believe so.
Okay.
His warrant was issued in August, though.
We have a UA on him.
Quiet, please.
I mean, we got his eye, so we can see him.
Do you have contact with him?
I don't think we do. Right?
No, I just.
Oh, you did?
Yeah.
Okay.
You, what's that? You
I
asked.
just asked, they have not.
But is pre-trial on him or just probation?
I don't know about pretrial.
Okay.
Just the attorney's office has contacted me. The voicemail I received yesterday. from
Oh, there's
the
Lydia.
stated taking it.
Lydia, can I ask you real quick, do you have, are y'all monitoring Paul Tompkins?
Yes, he's with Sierra.
And do you know the status of him?
I
Has
can-
she heard from him or?
I can do my
Check.
super spell. Give me one
Okay. Just need to do sentencing. What's that? Okay, let's do that one next. Royce Miles. I'm just sitting right behind the bar, but that keeps me knowing what's next. Okay, let's talk about, Mr. Pearson, can you come on up?
We will be doing jury for punishment on that. I did clarify that. No, sir.
So I would think a total of 4 days, possibly 5, depending on how long deliberations take.
Okay. All right, well, this is the oldest case by a long way, so I expect that's where we're going to go. You may continue to confer. If there's anything that comes up between now and then where y'all reach an agreement, whatever it is, then I'll be happy to take it. Otherwise, make sure that you're here about 8:45. Actually, I think, what time does our jury come now?
8:30.
Okay, so 8:30.
Okay.
Make sure you're here by that time and we'll get started picking the jury. Who's gonna try the case for y'all?
Joffrey Prager and Liz Dugan. Same people as last
Okay,
time.
same people. All right, very good. So we'll, they know in the order of things will come in. We'll get started with qualifications. We'll have a little break when they go out. We'll discuss things, but there's no reason not to believe that this won't be the lead case given the age of it. Okay?
Will we begin with openings on Monday after a jury is picked?
Yes,
Okay.
yes. On Monday afternoon, we'll do openings and start evidence.
And Judge, I did just have one other matter from Ms. Whitaker. She had filed a state supplemental motion in limine regarding a statement from a witness that was used to impeach that witness at the last proceeding. So she's just asked for a copy of that statement be provided.
Okay. Has that been filed?
It was filed yesterday, yes.
Okay, then I'm sure Joffrey will get to it ASAP. I'm just here for the docket call.
Okay, all right. And let's just get a minute so we can get an answer on Mr. Tompkins.
Okay.
All right, Mr. Pearson, so except for whatever your attorney needs, you're free to go about your business from the
Thank you,
court's
sir.
perspective.
Have a good one.
Okay, thank you.
Judge, for Mr. Tompkins, if he does not appear today, will our motion to withdraw be granted?
I
I think that's what we're gonna.
I know that's
we
what you're aiming for. Let me just, let's see what the status is.
Okay.
And see if we think he's coming in. I really appreciate you doing this.
Absolutely. Thanks, Judge.
Okay. Royce Miles.
Okay.
Everyone ready?
Yes, sir.
Ruby?
Yes, sir.
Court calls CR 22-4436C, the state of Texas versus Royce Michael Wayne Miles. Can counsel please make their announcements for the record?
Allison Boost for the state.
David Watts for the defense.
Okay, and are you the same Royce Michael Wayne Miles who pleaded guilty to aggravated assault with a deadly weapon in CR 22-4436C? Can you raise your right hand? You swear to tell the truth, the whole truth, and nothing but the truth?
I do.
All right. So we're here today for your sentencing. As I recall, and as my notes show, it looks like that you reached a plea bargain agreement with the state, and then your attorney asked that you be given a slight amount of time to take care of some affairs before you came to be sentenced. Is that right?
Yes.
And the deal we made was you do what you're supposed to do and not get in any trouble, take care of those affairs, and we would let you take care of your affairs, right?
Yes, sir.
And you did that.
Yes, sir.
All right, and you're here on time. I appreciate that. So thank
And
you very much.
we'd like to thank the court for the opportunity for him to line up his ducks with his family so that he can do what he needed to do.
Very good. Well, I mean, you came in with an attorney who is trustworthy, and I knew when he said and he vouches for you, that says a lot.
Yes, sir.
Okay. All right. So is there any legal reason we can't proceed to sentencing at this time? State?
No, Your Honor.
Defense?
No, sir.
All right, sir. Having found you guilty of aggravated assault with a deadly weapon, the court now sentences you to 15 years in the Texas Department of Criminal Justice. There will be no fine. there will be an affirmative finding that a deadly weapon was used. Is there anything else?
Nothing for the state.
No, sir, Your Honor.
Sir, I followed your plea bargain agreement. Because I followed your agreement, you do not have a right of appeal, and I'm signing the trial court certification. That will be added to your file. I must also let you know that because this is a felony, you are ineligible to possess a firearm or ammunition. Understood?
Yes, sir.
All right. Anything else?
Nothing from the defense.
Nothing from the state.
Good luck to you, sir.
Thank you.
Mr. Mouse, just need to borrow your right thumb real quick. It's right in the box.
Yes, sir. You ready on Michaelowitz? Yes. Mr. Michaelowitz, can you come on up, please? Michaelowitz. All right, are we here on the contested hearing today?
We are, it's scheduled, yes, sir.
Okay.
The judge scheduled it, for a fairly short leash.
Okay.
We,
I think I'm confusing this with Rodriguez. Rodriguez had to come back because.
that was a monitoring sentencing.
Okay.
It was,
That's
yeah,
not what this is.
but that was all resolved. We did come back a couple of times on that
Okay.
To clarify the terms and conditions.
Okay.
This is a true MAJ.
Okay. All right, so we're going to have a contested hearing. State, are you ready to proceed?
Yes, Judge, I do have one witness who isn't going to be here until 10, but she would not be the witness we're starting with. She would be the witness we're ending with, so.
Okay.
And if we are going to go forward, I'd ask that we do it this afternoon. I have several witnesses, professionals who've asked to have a little bit of lead time. And I wasn't sure exactly what the court schedule was today, rather than have them come down at 9 and sit.
Yeah, no, I get it.
I do anticipate that we are going to enter a plea of true as to at least one of the allegations, not all.
Okay.
Because one of the allegations is a new criminal DWI in Burnett County.
Okay.
So we can't plead true to it at this time, but there are other, I believe there are other allegations.
Are you going to proceed on that DWI?
Yes, Your Honor.
Okay. How long do you think you need to put on the case?
I would say, including cross-examinations, hopefully only an hour.
And how much longer do you need?
As far as the witnesses technically are punishment witnesses, so we would have to go through and that's why I'm asking the court, as far as the contested part of the motion to adjudicate, we would not have a problem going forward even now. But if the court finds true, and there's a sentencing, our witnesses would be sentencing and or mitigation.
Oh, okay. I didn't understand that. Thank you.
And I think the court may want to hear them in the court's decision as to true, though.
Okay.
As far as his.
All right, let's come back and do that one at 11:15.
Okay.
I have to speak at a Constitution Day, totally non-political. Just about Constitution Day at a high school in the afternoon.
Okay.
So can we do 11:15?
I'll be
here.
Does the court plan on doing the contested part, the hour, and then take a break for lunch, or?
No, we'll go through and be done by 12:45. That's why I'm giving an hour and a half for that.
Well, we will get through to our witnesses. Hour and a half if we're doing the contested.
Okay, well, we'll start at 11:15. We'll get as far as we can.
But we're stopping at 12:45.
Yes.
And we'll not pick up today.
No.
Okay. Would the court entertain giving us a reset on the sentencing or continuing the matter at a later date?
Yeah, I mean, I'm not going to cut you off if you have more witnesses.
Understood, but you kind of agree, because I don't want to call 2 or 3 professionals from Austin to come down here and be here at 12:15 just to be told turn around and go away, because I don't know if I'm gonna get them back down here.
Okay, I mean, let's get through the contested part. Sounds like they are people that would discuss whether he.
It's placed back on deferred and or whatever the court's determination is. Okay.
Oh, yeah, I think that makes sense. I want
that's
to
what
get through
I'm-
the contested part. The state
Okay.
hasn't made an accusation against him, and I want them to
The factual part of it.
put that factual part
With
of
the
it.
understanding I'm not gonna have those witnesses here, just because we're on short leash today.
Okay. Okay.
Okay.
I think that makes sense. Does that state make sense for you?
I work on your schedule, Judge.
Okay, we'll do that.
Thank you.
Let's do 11:15.
Thank you.
With potential to push to 11:30 if we're still got a few things that are.
Yes, sir.
going. That's my goal.
It's an old docket matter that was on today's docket.
What's that?
There was a case, Mr. Villanueva. That
It's
apparently.
not on the docket today.
Well, it says it was canceled at my request. And that's why apparently the state gave the court a dismissal on it yesterday and the court signed it.
Oh.
And the problem being, normally I would not object to a dismissal. The problem being, the email I got was that there was more evidence coming in and they needed to process that. And we're not ready to go forward, knowing that we were probably setting for a trial, which tells me they're going to dismiss, re-indict later, so we're going to have to be arrested and make a bond. And so if that was the case, we object. Now, if it's a dismissal with prejudice, no problem with it.
Okay.
But if it is just simply a dismissal to avoid going forward, and we're going to be re-indicted and have to make a new bond later, I do have an objection. And so that's
I mean,
why,
I think the bond should be handled accordingly if he's already paid a bond on this exact charge.
but that's not how they do it. It's
Well, I mean,
We're happy to reach out to defense counsel prior to filing any additional charges and letting him know in advance so that he can prepare his client to do a walkthrough or whatever needs to happen.
but see, we still have to do.
well, I mean, I think at
We
this
have no
point,
rest.
it's dismissed. If that comes up again and you want to bring it to the court's attention, I'll be happy to entertain it at that time.
I understand. The problem is it may not come to this court. I mean, I understand that, but that's, and I do very much appreciate that.
I think they're trying to bring those back to the court when the state dismisses, that they're trying to bring it back to the court.
I understand.
And you may be saying may not be in front of this court.
No,
and
there's
that's-
several
and
other
that's the
courts
case
that when they get the pre-file number, it's just a number and it gets the letter.
Yeah, but I mean, that's what I understand they're trying to do, is that when it's a case, so they're not restarting with another court, that would come back to the same court, and it's not randomly. It's the same way that if someone already has a case pending in another court, they would assign the new case here. I think that's what they're doing.
But it's after the fact. It's after I've already we've had to go down on the warrants. I just think it's unfair to a person to have to go through the process of being rearrested, having an arrest, and us having to even go through that process when the dismissal is based on that. That's my objection.
So as I remember it yesterday, the reason that was given is for further investigation.
Correct.
Is that right?
Yes.
Okay. And, you know, the state has the right to do that.
I understand that's not what my email says.
Okay, well, if you, I mean, if you want to set it for something, let's.
Well, I don't know what we would set it for. It's
dismissed. It's not.
And that's why I normally would not necessarily object. As ex parte motion. I think we have a right to be heard on it at least, or at least an opportunity to agree.
Okay.
We were on the docket. It's been taken off. It says by my request, it was not.
Okay.
So I'm just trying to address that.
What's that?
I just showed us the wrong option. I already let you know that.
Okay, understood.
All right. Very good. Thank you. Hello, Mr. Matias.
Hello, Your Honor.
How are you?
I'm fine.
Who are you here on?
Well, I'm here to correct the record.
Uh-oh.
I was here yesterday.
You were?
And the case of Ariely Flores Velasquez was called. It was
Yes.
on the docket sheet, which surprised me. Because my calendar showed that it was set for today, because it's the announcement docket. But I didn't have my file. So I went home, I looked, and this is there were two settings given, but this one was crossed out when I informed the court coordinator that it was a trial setting. So he's really supposed to be here today for trial on the 23rd, not yesterday. That was a mistake.
Is he here?
Oh, he's still not here, but I just want to correct the
Okay.
record. I don't,
Okay,
I've been trying to get a hold of him. He's not here.
but he's not set on the trial docket for the 23rd. Can I-
On my calendar, he said.
Why don't you go show those to Becky and see what, and I'm happy to hear whatever you want to bring to the court's attention. Is, due to that medication, is that what you're gonna get? Okay. What?
He has verification of the prescription.
What did we test? Why did I test it? Oh, because he's got a.
Yes.
Just go. Okay, so he's back. Is he back in here? Is he back in here?
Yes, he's in the blue shirt, Your Honor, over here on the second row, is it? I looked at his attorney.
So his attorney was here.
Yes.
Okay. Got that one ready when you are ready. All right, you ready? Who's next?
May I approach you?
You may, of course.
Here for Eric Sundin.
Mr. Sundin, can you come up, please? How you doing, sir? Pretty good. Thank you for being here on time. So it looked like last time we were here, there was an outstanding question of discovery that you were waiting for written statements. What's the status there?
I've received one of the pieces of evidence that we're looking for. I think there was a miscommunication about the second one. And so I've relayed that to the prosecutor, and it's my understanding they are going to continue looking for that missing piece of evidence.
We were informed that there was an additional 911 call placed by the defendant that we had not initially received in discovery. We have since requested it and are waiting on receiving it. I anticipate having it within about 2 weeks.
Is that the final issue on discovery?
Yes, Your Honor.
Very good. Do you have an offer?
Yes, Your Honor.
All right, we'll reset this while you get that information, that last bit of discovery. All
Thank
right,
you.
Thank you very
Judge.
much.
Appreciate it.
Is that going to be a pretrial or a plea?
I think we're. Yeah, it's a pretrial.
Okay.
Are y'all ready to move to plea?
No, I would just want to make sure my notes were accurate.
I like
so.
your enthusiasm. Very good. All right.
And then I also have Roman McKibben.
McKibben. Mr. McKibben, can you come up, please? How you doing, sir?
Good, yourself?
Good. Thank you for being here on time.
Yes, sir.
No problem. Saw that you have discovery and an offer. What's our status here?
He's currently working on a mitigation packet, Your Honor. He is in the process of finishing a class as well as putting another UA.
How much do you have left on that class?
I think it's 15 hours.
15
That's
hours?
just what we just talked about.
Can you finish it in the next 30 days?
Yes, sir.
Okay, all right. Then what we'll do, we're gonna move this to a plea setting. That does not mean that you have to plea, but if there's not some resolution, then the next setting would be a trial setting. Sounds like though you're doing all the work, make sure you get it done, because only can the state review that mitigation evidence if you provide it to your attorney, okay? So it's really on you. It's not, it can't be on him, because I know he'll get it over, all right? Very good?
Thank
All
you,
right.
Judge.
Very good, thank you.
And then one more, Your Honor.
Okay.
The Garen Majestra.
Mr. Matrestro? All right. So you have discovery, you have an offer. What's our status here?
I need just a little bit more time to talk to the client, Your Honor. Previously, when we had some communication, they reached out. I had COVID, I was sick, wasn't able to accurately reflect the communication. So we need one more setting so I can continue to go over the case with them.
Yeah, not a problem. Make sure that you're communicating with your attorney, because he can only help you if you're cooperating, right? All right, so we'll do the same thing. We're going to move it to a plea setting. It does not mean that you have to plead, but if there's not a resolution, then the next setting would be a trial setting. Understood?
Yes, sir.
All right, make sure you're cooperating with him. He needs to hear from you. All right, thank you very much. Have a good day.
Thank you, Judge. May I be excused?
Yes, thank you very much. How are you doing?
Good, how are you, Judge?
Good. Who are you here on?
I'm here on Patrick Jones.
Jones.
Mr. Hayes.
I'm here on behalf of him. My name's Tony Sabsky.
How do you spell your last name?
Sabzkooh.
Thank you for being here. Where'd you come in from?
From North Boston.
Okay. Well, thank you for coming down to our little county. Mr. Jones, can you come forward, please? So last time we were here a month ago, there was still the issue of the state providing discovery. State, have you been able to do that?
Yes, Judge, we actually provided it last time. We just had to do the protective order for the CPS records. Those have been provided, however, they are quite voluminous.
Okay, so is that all handled?
We just got those last week, so we still need some time to go through that.
No problem. All right, we're moving forward. We'll move this to just another pretrial setting. Thank you very much.
Maybe excuse me.
You may. Thank you for coming down. Have a safe drive home.
Thank you.
Yes.
Good morning, Your Honor.
Good morning.
My name's Jackson Gorski.
Nice to meet you.
Lead counsel on, nice to meet you as well, on the Tucker matter.
Mr. Tucker, can you come forward, please? Where'd you come in from, Mr. Gorski?
Austin, Your Honor.
Okay, well, great. Thank you for coming down to Hayes.
I went to school at Texas State, so I'm quite familiar.
Yeah. Well, good. Go talk to the Texas State students and tell them about going to Texas State and ending up where you are now. All right, we're set for a. You don't have it, that file? Can we get it brought up? Okay.
Also, I took the liberty, there was an error on the proposed order, Your Honor. I e-filed it this morning, but I also have a hard copy just in case.
So they'll get the file right up.
Yes, sir.
Let's come back. All right, so I want to make sure I have notes on everything that's going on. All right, thank you. Hello. Good morning.
Have you requested a drug test for Nathaniel Ramirez? Here's his results, negative.
Very good. This is the one, as I remember, that we had a helper last time.
Yes, that is correct, Judge.
Okay.
And then I have an update for Paul Tompkins.
Okay, Ramirez. Yes, Paul Tompkins.
Sarah has not been able to reach him since August 7th. She's reached out to his mother a few times, and she also has not heard from Paul as well.
Okay, yep, Paul Tompkins. So pretrial has, when was the last time pretrial had contact?
August 7th.
And they'll still continuing to try to reach him
Yes.
But no luck. When was last time probation?
It was August the 14th. He reported in person and that was when we had to serve a warrant. So that's the last contact we had.
Was he tested that day?
Yes, he was.
What was the result? Do we have a warrant for him already? All right, well, y'all keep trying.
Okay.
Thank you very much.
Thank you, Judge.
Yep. Ms. Rodriguez? From the Hays County Women's Center? Oh, you're here. Good. Come on, come on. Invite her into the jury box.
I appreciate it.
On that other issue, Your Honor, the last positive we had for him was for meth on 8/12.
8/12.
Yes, so no UA was taken, oops, yeah, on the 14th.
Yeah, that's my concern. Well, let's keep trying to make contact with him, see what we can do. I don't have your motion in front of me. I mean, the order.
Okay. You want us to resend everything?
No, you don't have to resend everything.
Okay, we'll get that to you today.
Okay.
Thank you.
Or if you want, just, I don't know how it would get to me. If you want to just bring it on Monday, we can do it on Monday.
Yes, okay.
Okay.
We can do that.
Okay, that makes sense. Yeah, I was gonna tell you, if you email it to me, I can print it, you know, give it to the court. But if you're gonna take care of it Monday, that
We'll
works.
be here Monday. Thank you.
I think the order's already been emailed.
He just needs a hard copy to sign.
Okay. I'll come back to Kate Tucker. I don't know where he went. Looks like he stepped out. Let's take up your case.
Candace Evans for Mohammed Rajput.
Who are you for?
Mohammed Rajput. I'm sorry, I was down in the jail.
No problem. All right, so we need to bring him up. What are we gonna do on his case?
Your Honor, originally it was my understanding that we had a deal. I was hoping to sign plea paperwork today. I got here today and the attorney that I was speaking with is not here. And Miss Royce.
It's Molly's case, Judge. Apparently there was some, from my notes, it appears that she was considering doing 1244, but that's something that has to be approved by me before it's official. And that has not been done. So I made the state jail offer on the case. Defense counsel would like a reset to be able to talk to Molly again about that 1244 offer.
Okay, let's do it. We gotta get him up.
Coming up.
Thank you. We'll get him up and
Do a short recess.
yeah, we'll do a real short
It was gonna
one.
be a
Since
time
he's in
served.
custody, that needs to be
Yeah.
handled. Get him up. Whatever the shortest reset we can do on that one, we'll do.
We could even potentially put him on Monday, Judge.
Okay. There we go. Monday.
23rd, yes.
Are you at NDS now?
I am.
Okay. I'm Tana.
I have met you.
We have.
I've been here since about April.
Have you? You've been in here though?
Once or twice.
I don't recognize you being in here. Usually it's Ferrado and Dow. Very good,
Yeah.
like them.
Yeah,
Well, I apologize.
just a few times.
Yeah. okay.
Mostly an A.
Have you come to the court and have you been up here today?
I don't know.
Okay, so it's possible that you haven't
Potentially,
been up
very
here.
potentially. Yeah.
Okay,
It's very possible.
well, I wanted to apologize.
I know, it's okay. It's okay.
Otherwise.
You know, I don't know at this point.
He stepped down maybe.
Why don't you step back while we take this out? Yes, you may.
My apologies, I was
No problem.
answering some emails.
Ms. Buse? All right, we're set for trial on your case. And you have a motion?
Yes, Your Honor.
Do you have it? Do you have a hard copy?
I do, Your Honor. Here's the hard copy, and then the proposed order had an error, so there's a new fresh copy.
Okay.
Your Honor, in regards to my first point, Denise Kadirhan was my co-counsel. She has filed a motion to withdraw. She's refunded the fee, and I have been able to retain Leslie Booker, who has filed a letter of representation for the court. So that should be making its way through the clerk's filing system.
State, you want to be heard?
No, Your Honor, state's ready, but that's our only announcement.
Okay, well, still has lead counsel, and the motion is insufficient on point 3. You have to tell materiality and those elements for it. So for now, I'm going to deny the motion as written.
I'm happy to elaborate on that point, Your Honor.
For the motion. Just need to make the motion be consistent with the code.
When you say materiality, you mean as to what that expert would testify to?
That's right.
Okay.
You know it. Just needs to be done.
Yes, Your Honor.
Okay, and you all can continue to confer. Let me know if you want to reapproach on that on a new motion.
I shall get one filed immediately, Your Honor.
Okay, very good.
Is there a notary in the courthouse?
I don't know the answer to that. I would guess the answer to that is yes.
You just need to find that.
That's right.
If you need it, I'm a notary. My stamp's downstairs.
Yes, I'll be, thank you.
Wow, that was easy.
I'll be
And
drafting it right now, Your Honor. May I be excused?
Very good.
Just
Yes,
a
you may.
moment.
Is anyone else ready right now?
And Judge, the state had one witness on this Hart, but she has a doctor's appointment. I've told her we're not going to make her miss that doctor's appointment.
Okay.
I don't see Mr. Dudley, but
What are we
if it's
doing on that
a few
one?
more minutes. She is going to need to leave for that, but she'll come back after.
What are we doing on part?
It's open punishment to the court.
Okay.
Good morning, Your Honor. I have Ms. Cortez who is up. She has a number of cases that we like open to. There's a PSI done.
Yes. Yeah, I've seen this.
And yes. Over here.
Yeah, I see. I hear this one. Are we moving forward on all of them?
Yes, sir. She pled open on.
All but the last case, Judge, which was newly indicted.
Which was a
CR 242489-F. It's another theft third. So we intend to file a motion to dismiss that case.
So we don't have any cases before the court that are after 2022?
That appears to be correct, yes.
And the 2024, what is the charge?
Theft third.
But not filed, not indicted.
It is indicted. It's something that we had agreed to decline as part of the plea deal, but ships passing in the night. Intake didn't get the memo and presented it, so it's now been indicted, so we will be dismissing it.
Rosalie Cortez. Rubio, you ready?
Yes, sir.
So are they all state jails?
No, Judge, there's also the possession case, which is a second-degree felony. That should be CR 22-2341-A.
Court calls CR 19-2256A, CR 20-4785A, CR 20-4786A, CR 20-6107A, CR 20-6108A, CR 22-2341A, and CR 24-2489F. Can counsel please make their announcements for the record?
Allison Boost for the state.
Matthew Nichols for the defendant.
And are you the same Rosalie Cortez, who in those cases I just named is charged with five counts of theft, 2 prior theft convictions, and 1 count of possession of a controlled substance, heroin 4 grams or more, but less than 200 grams?
Yes.
Can you raise your right hand for me? You swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right. Counsel, I've received a pre-sentence investigation report from probation. Have you had the opportunity to review this report and discuss it with your client?
Yes, Your Honor, I have.
Are there any corrections or modifications to the report?
No, Your Honor.
Is there any legal reason we can't proceed to sentencing?
No, Your Honor.
Argument. You came in and your agreement was that you would go open to the court, meaning that the full range of punishment is available. That's 180 days to 2 years in the state jail facility on the state jail cases, and 2 years to 20 years in the possession of heroin. Is that your understanding of the agreement?
Yes.
Okay. State argument?
Judge, I think what the court has before it right now is someone with an extensive criminal history, someone who has continued to harm our community over the years, has had multiple opportunities to change her behavior, to seek treatment and help on her own, and has failed to do so. My concern at this point has to be the overall safety of the community, and I think this defendant has proven herself to be a continued threat to that community.
Your Honor, I would argue that.
Do you have any argument on what you want?
Judge, at this point, I think prison is appropriate.
Your Honor, these are Ms. Cortez's first felony convictions. She has no previous felony convictions. Want to make sure that was correct. Double checking.
It looks like she was, her previous felony theft was reduced to a misdemeanor.
That was my understanding.
In Travis County.
Yes, sir.
So no felony convictions until now.
Yes, sir.
Yes.
And so although these are all, the 5 theft cases are all misdemeanors, which have been enhanced because for previous theft convictions. So, and then the drug case, she clearly has a drug problem, which she was very honest with probation with. She is a heroin user, and she is hoping, and I think it is in the best interest of society, for her to get treatment rather than prison time. Probation has recommended safety. It's my understanding that on drug treatment options, it's better to start at the lower end of drug treatment and then work your way up to the more restrictive and longer drug treatment. It's been shown to be more effective. So we would ask that instead of safety, if you agree to a probation, that she be sentenced to the day treatment from jail which would be at the beginning of the sanctions or the treatment continuum. So later on, if she
You said day treatment from jail?
We don't have that. We do not have that.
I'm sorry, then a shorter inpatient treatment. But I don't know off the top of my head what that would be, Your Honor, but something other than the longest and so that we would have the option later if she were to continue to not be able to stay sober, to have the safety at a later time if she needed that at a later date.
Is there another inpatient that you would recommend?
Your Honor, we were actually wanting safety specifically for this client. There's also as the other options for long-term residential would be Central Texas Treatment Center or Uvalde, those type of situations.
So is there one that would be consistent with his ask that you would recommend, where she goes into an inpatient that is short of safe P?
Smart.
If you can you identify yourself for the record and just speak up so that Ruby can hear you?
Bailey Benson, Hays County Probation. Smart 90-day program or Uvalde 9-month program.
And tell me about the Uvalde program.
It would be a 6-month program and then a halfway house after that. And that's a lockdown facility as well, substance abuse treatment.
And does probation facilitate that, or is that something that she has to do on her own?
We would facilitate that.
Okay. All right, let me ask you, here we are. On the one hand, I think it's time for you to go to prison. And then your attorney's arguing for the least amount of treatment at this point. And not the Safe P program. You know what the Safe P program is?
Yeah.
Okay. So why should I believe that this is now the time to go on the shorter term program, not Safe P and not prison? Has anything changed in your mind?
The last couple of years, I've had a really a lot of things changing in my life. I lost my husband of 25 years. I have 3 kids that are now only with one parent, and my mother-in-law has constantly been at my back. She's accused me of killing my husband, all kinds of things.
How old are your children?
My oldest is about to be 18 in October. My daughter is 10 years old, and my middle son is 12.
And what does their not having their mom mean to you?
I mean, I haven't been able to hold my daughter in the past 3 years because my mother-in-law has put all of these false CPS charges on me, and I've been fighting them ever since my husband passed away. Every time I clear them, she puts 3 more. She has somebody call in 3 more charges on me, and then I'm not able to pick up my kids.
So here's my concern about part of you being successful is recognizing that you are the problem, not your mother, right? I mean, if you're doing heroin and you're picking up these theft cases, 19, 2020, 2022, that's your mother-in-law's not doing that to you. So for you to be successful, it's going to mean that you have to understand the importance of going into these programs and getting clean.
Yeah.
Why are all these thefts? Why is that happening?
Well, at the time, my husband was really bad off on drugs, and he was spending we lived off of his disability. He was a veteran, and all the money that he was earning, he was spending on drugs. So I was having to supply, food and clothes and stuff like that for the kids. And
you were using too?
At the time, no. I started using after, but not at the beginning.
When?
Well, like a couple of years after he started using.
So when did you start using?
I was off of it since he passed away in 2022. And then my mother-in-law, she had my disability checks. I was receiving his disability and she had them stopped. and I became homeless, and I just spiraled out of control, and I was started using drugs since then. I mean, like December. And I've just been self-medicating. The day I got picked up on the drug charge was the day after my husband died. My brother-in-law at the funeral home, while we were planning my husband's funeral, called the police and told them I had a warrant for my arrest and that they didn't want me at the funeral home. And they came and arrested me that day at the funeral, and I had drugs on me, but I was upset. My husband had just died the day before. I mean, I was self-medicating. I didn't have anybody to help me mourn. I was all alone. I went from having everything to having nothing in less than a day.
Have you been in custody since you were arrested that day?
No. My friend helped. Nobody would help me get out, so didn't know if I was going to make it to my husband's funeral. My friend helped bond me out, and I hired me an attorney, and I got bonded and made it to the funeral the day before.
Okay, and then since then, you've gone back to using.
Yes, after became homeless. Yes.
Okay. And when did you go into custody this time?
I've been in custody since the 26th of May.
Was when she picked up the most recent theft, Judge.
And the only reason that I was still in at that time was because I had nowhere to live and I had no place to stay, and I was having to provide myself. I had no money. I went from getting $3,000 a month to getting $80 a month.
Well, you were using your money on drugs, right?
No,
No,
not at the time. I'm sorry.
I mean, what I'm trying to see is if you're ready to go into these programs, because they're going to put a lot of effort into you to helping you be successful and get off
I'm
of drugs.
ready to be clean. I've been clean for the past 5 months since I've been, and I don't have any desire to go back to it. I promised my daughter that I would hold her every night and that I would take care of her and I would be the mom that I know I can be. And I want to do that. I want to be that mom. I miss my kids so much. I've never had to be without them ever since my husband passed away. The day he passed away, I lost my whole family. I lost everything.
So you have the motivation to get off of drugs.
And I'm ready for it. Yeah, I've been doing my 12 steps. I just couldn't turn in the certificate because our tablets are down. But I've been taking the classes and doing all the stuff that I need to do in order to prepare myself for being out and being.
Are you doing AA and NA in?
Yes, in jail.
In jail?
Mhm.
How's that going?
Going good. Going
Is it
good.
helpful?
Yes, I don't need the AA because I'm not an alcoholic. I don't drink, but I've been doing the NA and I've been doing the tech classes on the Indovo app and that type of stuff.
How often do you do NA right now?
She only comes once a week, and sometimes she doesn't come every week. I think she had something happen or surgery or something, and she had been out for a while, but she's been coming every week.
Is there any legal reason we can't proceed to sentencing?
No, Your Honor.
Your Honor,
Yes.
can I just add to that?
Let's identify you for the record.
My name is Angela Winkenwerder with Hays County Probation.
Okay.
The reason why we were recommending safety for this particular individual was because of some medical issues that she has that might make placement impossible at the other venues. Correct.
So I'm thinking SMART, if anything.
SMART will not take her, nor Uvalde. No one will take her except SafeP due to her having MS, depression, anxiety, and being on medication. The only place that will take her would be TDC ISF substance abuse track or cognitive track and SafeP.
And it's the recommendation of probation that it be SafeP.
Correct.
Sounds like those lesser options are not available, and she needs to be an inpatient.
Yes, sir.
So I think that tells us where we have to go.
I understand, Your Honor.
Any legal reason we can't proceed to sentencing?
No, Your Honor.
No, Your Honor, I would just point out to the court that because she does have so many cases, we do have the option to sentence her on, for example, the state jail offenses to state jail time and then place her on a deferred adjudication on the second-degree felony and allow her to receive that treatment but still have hooks in her.
Well, I mean, if she goes to SafeP, she would go immediately, right?
Are we gonna have her serve her state jail time and then come out and be on, placed on probation?
No, I'm ready for her to get started on treatment. Thank you, State. Having found you guilty in CR 19-2256, CR 20-4785, CR 20-4786, and CR 20-6107, and CR 20-6108. The court now sentences you to 2 years in the state jail facility that will be probated for 5 years. You will do the SAFE-P program. You will do frequent UAs. You will do NA and AA at least 3 times per week when you get out. Hopefully there you'll be doing similar programs. You'll do the moral recognition therapy course, and you will be in the specialized caseload with probation for substance abuse. There will be no fine or fees for this case. All of these will run concurrent. Probation, anything else on those that we need to, that are special? Okay, on the CR 22-2341A, possession of a controlled substance, heroin. I found that there was sufficient evidence to substantiate your guilt, but I'm not finding you guilty at this time. What I'm going to do is grant your application for deferred adjudication. You will have the same conditions that you do on the state jail felony cases, and that will run for 8 years. Is there anything else we need to take up?
Yeah, Your Honor.
Ma'am, these are felonies. Because they are felonies, you're ineligible to possess a firearm or ammunition. In addition, I have followed your plea bargain. Because I have followed your plea bargain, you do not have a right of appeal. That will be added to your file. But setting aside all of those legal things that I have to say, like, this is up to you now, right? You didn't get the prison, and that's may have been the most fair thing, but you say you want to do this. And so the keys to your future are yours. Despite all of these cases, you can now go and do better. I mean, and it sounds like you have a reason to do it between your children, or maybe because of your children stop there. And the probation is going to be here to help you, right? They are going to help you after you get done with these programs. Be cooperative with them. When you have the questions of where you're going to live and how you're going to take care of people, talk to them, all right? And they are going to get you the help if you are willing to be helped. Are you?
Yes, I am. I want this.
All right, I want this for you.
Thank you.
All right, good luck to you, man.
Your Honor, can I ask just a couple of clarification?
I'm sorry.
Who's speaking? Sorry, it's Angela Lincoln Order. Are we going to assess any community service in any of these cases?
No.
And on the one that you just probated for 8 years, there was $288 in restitution.
Yeah, you need to pay that.
And then as far as attorney's fees?
Attorney's fees, have an argument?
Your Honor, I asked my client is clearly indigent. I asked that he waive and concurrent.
Okay, we'll waive those. Yes, ma'am. All right, anything else?
Nothing from the defense, Your Honor.
Nothing from the state.
All right, thank you. We're off the record.
Thank you, Your Honor.
I need a bunch of thumbprints. Straight up, straight down on the pad, straight up, straight down in the box.
Thank you.
All right, good luck to you, Ms. Cortez. Follow through on this, okay?
will. Thank
Good,
you.
I hope you will. Thank you. Did I name safety? Yeah, I did say it. I did say it. Students, have y'all ever seen these? No, because the last time a printer like this was made, you weren't even, your parents probably weren't even married. It's so old. It's, these old things come out. But the important thing on them are these are all of the terms and conditions when you're on probation. And so the defendant goes through and they go through all of these things. They say, this is what you have to do to be successful on probation. And so it's all laid out up front on this funny paper. That's what this is.
Hopefully we run out of the paper soon. We only have a few more boxes left.
I love it. I mean, it's unique. It sets things apart.
I like it, so everyone can get their own copy.
That's right. What's going on? Okay. Yeah. All right.
Yeah.
You have class. Okay. Got NA 3 times a week.
Yes, I'm gonna add all that.
Okay. Yeah, I have to add all that. All right, are we ready on yours? Come on up. Thank you for your patience. This is Ms. Rajput.
Yeah.
How do you spell your last name?
R-A-J-P-U-T.
How do you say that?
Rajput.
Okay, very good. We are here on a pretrial setting for you today. Defense, do you have an offer in this case?
Yes, we do. Originally, before coming to court, our offer was a time.
You don't have to tell me what it is.
Yes, Your Honor.
This is the one where we're clarifying the offer, Judge. We're gonna bring him back on Monday.
Okay. All right, so do you have discovery?
Yes, Your Honor.
Very good. All right, what we're gonna do is evidently your attorney's come in and she's been negotiating with the state. They still have some more negotiations to do, but because you're in custody, we're gonna come back right away and consider what these options that the parties are talking about on Monday. Understood?
Understood.
Okay, I'll see you back then.
Okay, thank you, Your Honor.
Thank you very much. How many days does he have? Yes, so we're gonna move that to a plea setting. That doesn't not mean that you have to plead, but if there's not some resolution, the next setting would be a trial setting. Understood? All right, very good. Are you ready on Hart?
I don't believe we have Todd that week.
I chatted and forgot how to respond.
Todd has disappeared.
He may be talking
You ready to, Ron Hill? Mr. Ron Hill, come on up, please.
I'm sorry about being a little late, Your Honor. Mr. Ron Hill's wife, also the alleged victim of the violation of protective order. Apparently she was in the courthouse today wanting to speak with prosecutors and spoke with, I think it was victim assistance coordinator, and I thought that might change the state's position, so I was waiting to make an announcement after that.
It is not going to change the state's position, Judge. We are ready for trial.
Okay. How many days do you need to try this case?
1 or
Day
2.
and a half.
Yeah.
Is punishment to judge or jury?
Sure.
Maybe 2.5.
He is. If his application for probation is not on file, we'll get it in.
Okay. Yes, you're ready?
Yes, Your
All right, very good. So we'll be back here at 8:30 on Monday. We will start qualifying the jurors, and after we do that, then there will be a time when there will be a break where we'll go on which case. I can tell you that there is a case much older than yours that needs to be tried.
Sure.
But that doesn't mean that something can happen on that one, and you would be up. This case has been around here for a while, so let's take care of it.
Okay.
Okay, thank you very much. Tucker, we coming back?
Your Honor, I need to swear to this motion, but as soon as I
Okay,
get it
take care of that.
My stamp is downstairs, so I have to. Just can we maybe take a 5-minute break?
We can, yeah, let's do that. Let's figure out, what do we have pending then? We've got 11:15, we've got the hearing, and we need to do Hart before that witness leaves.
She's actually moved her doctor's appointment for us.
Oh, is that you?
Officer Bennett that's sitting back.
Oh, okay. And who are you here on? Okay. Very good. All right, so we'll take 5 minutes if anyone needs a break. Students, come on up.
It's the last one, Mr. Cortez.
How y'all look today? Very professional. Thank you very much. So much. Everyone looks ready for court. I appreciate that. You know, we want to treat the court with the decorum that it deserves, because this is serious. You see what these people are going through. For many of them, this is the most important or the toughest day of their lives, right? Because they're going to be sentenced to something, or they have to make a big decision about their future. So what do you think of what's going on? What questions do you have?
Wrong to say enjoying.
It's what's that?
Wrong to say enjoying it, but nice to be in the process.
Yeah. Yeah, to see what it is, you know? Is this what you expected? No? What were you expecting?
Well, I don't know. I don't know. I wasn't expecting it to look like this first. I thought we were gonna be like sitting back there still.
Yeah.
And then,
Well, you get a better view from there, and
Yeah.
it's more comfortable chairs, you know, trying to take care of y'all. So you weren't expecting this, and then, but from there you get to see the attorneys. What do you see about, what are the attorneys doing, the state and the defense? What are your impressions there? Understand what I mean? Like, what is it that you see?
The way they work together.
Yeah.
They
They-
just talk it out.
They have to work together, right? This isn't, you know, people think that the attorneys are just always at each other, and that's really not helpful to these cases and for their clients. I mean, these cases can all end up in trial, and so, or they can find something that may be better for the defendant. You know, the state needs to pick and choose what's the most important cases for them to prioritize. And so you see there's a lot of negotiation that goes on here. We've had, you also see the majority of the people are not in custody, right? I mean, you look at our numbers here. You know, maybe 20% here are in custody. The majority of them are out on bond, which, you know, allows, I'm sorry? That's something that people don't usually know. They think that everyone who's waiting trial is in custody. And then you saw, for instance, a sentencing. And what happened in the sentencing is we come forward, the person takes the plea agreement. So they just told me there was going to be a plea agreement. I really want you all to see that. So that's coming up. After we take the plea agreement, if it is a case where there's the potential of probation, then there will be a report prepared. It's called a pre-sentence investigation report. Now, if any of you are interested in working in the courthouse and this sort of work, like maybe being a probation officer, because you are in CJ, that could be it. They put together these packets for us. They will interview the defendant, and they will tell, here are the defendant's background, what they have done in their, if they have a criminal history, if they don't, what they're, when they graduated from high school, if they didn't, what kind of education they have, what kind of family background they had growing up. And we take all of that into consideration. I get these and I read these before we come in here. It'll tell if they've been testing positive or testing dirty for drugs. because that's what you see so much, like this woman who was before us that you just saw. This is largely driven by, like all these thefts, by her substance abuse, right? She's doing heroin. I mean, and remember that chart that we talked about when you're coming down off the drugs? We started with the hamburgers, we moved up to cigarettes. There's something else in there. We won't go into that, right? And then there's cigarettes, and then cocaine, then heroin, and then meth is way up there. But heroin's way up there too. And so when they're coming down, that's when you see all these thefts will happen, because they have to get another hit. And so they'll go and seek out something that they can steal, and then they can sell it, and then they can pay for the drugs. So it's just this vicious cycle that we get into, and the thing was there, you have to find people who are willing and interested to get better. I hope she is. I hope she is. She's going to get a chance now. She's got a long path ahead of her through the court system, but it may actually be better on her to be in the court system, because she's going to get support from the probation office. That's their job. Their job is to help people be successful on probation. So you saw that. I use this report in order to do that. I've got to talk to one more person, but why don't I ask you all to step over there? Probation, will you just talk to students about what y'all do, what it is you do, and share with them, and then y'all take a seat. We're going to do this plea soon, and you can see a little bit more of how we do it. Thank you. Ms. Rodriguez, I'll meet you at this door.
So when that happens, some of those conditions could be something like available members of the court. You go to classes, like treatment. Go to there's like neural recognition therapy, which is a cognitive class to help them better their thinking processes. There's community service, where they get back to the community. And then as all these orders remain with their officers, it can be anywhere from weekly to monthly. And once you're doing well, we look at this laundry list of things that you're supposed to do, and as we complete them, we check them off. We do drug testing, and that tests for the presence of drugs and alcohol in your system. And then if there are any issues that come with that, we can get them treated.
Attached to us.
If you're interested, there's like listings and information about what we do on it. There's a Hays County adult probation, and there's also some information about specific classes that we offer.
So Williams.
Yeah, we're gonna try to clear it real quick here.
Oh, did you have it?
That was good.
Well, actually, it's there. I have
2 weeks. Yeah, I can see it.
You have to search for it.
The law number.
Yeah, did it work?
Yeah. It is.
No, typically the e-file, but exigent circumstances. If the order is proposed,
I love this special. We don't.
I think this was. It's apparently my co-counsel promotion was not accepted. They got kicked back. I'll need to swap it out for paper. And so this is to verify it's not the same. Come into the case. It is. I think it's a good idea.
You start over when you.
Well, the bank case is set for the 24th. So that's likely. Yes. It looks like only this one. Probation.
Hey, I'm not gonna turn down any backup.
I've met a lot of people in the
I gotta go.
Yeah, we did, yeah, I was just thinking of the judgment. I did, the two things were that they want jail, they're recommending jail time as a condition as well as all things. Weapon is prohibited play. I don't know that that's such a one aspect of that. All things prohibited.
I didn't hear that based on the facts that they had for our
I mean, I get one, but I mean, obviously, going to ask the court not to impose a lot of things. You got 20 years, you know, with the fucked up. And I mean, you did the first offense and the second time that justified doing probation. So you said that you guys did but I mean, obviously, it's so, I mean, my case, and you guys will do what it is.
That's true too. Generally, it's
Yeah, I feel like I'm correct.
Yes, that's what she said. I really don't want to crack them on the wild. I really don't want. Yeah, I can't remember. Okay, sounds good. I'm gonna sit right here. Really. See what kind of. Much appreciated.
That's all they need. I relayed an offer to him on the rain case. I think that's. Does he care if I sign first?
No, you're fine.
Waited until they say it's cool. So ideally, we like to do a name person. Otherwise, we'll just send my name. Is Jamie? Oh, she's. Jamie's filling up. That's working on the room.
What do you got?
Yeah, I was thinking about you for just one second.
Sure.
Mason Castillo is on the docket down the hall in Tibby. This is our ag kidnapping,
I know.
smuggling, the whole shebang. Is there any way that you guys would consider doing a hefty non-ag, just like on like 15 or 18 on the kidnapping?
No.
So you're just firm at 30?
Yeah, I'm pretty solid on 30.
Okay. Cool. All right. Well, I told her that.
Taken care of.
Yep,
Me too. Did you get a chance to read the PSI?
I did.
Read pretty good.
For you, yes. That's why I'm gonna have to call Bennett to clarify some of these claims that have been made.
By whom?
Ms. Hart. This was kind of an isolated incident thing that she didn't even know Bennett was working, that Bennett's fixated on her, and that Bennett's mean to her.
Yeah, you sort of have to. It feels like every time I talk to her, Miss Hart seems like she's doing a little bit better. I think it's, gosh, she's been jailed a long fucking time.
None of us are arguing that she needs to be something. That's not the issue. The issue is just, I need the judge to understand why we're asking for certain conditions on her supervision, why we're gonna be asking for a GPS monitor, why we're gonna ask for an exclusion zone, all of that stuff. So I need him to understand, like, this is not just a like little mistake or.
So we have the, I do the protective order. Forever I did it. When those protective order granted against her, and I remember those a couple of things, but I can't really remember. I guess I'm just not that what the incidents were.
Oh, by the way, she'll be entitled to it by law, but if you want to look over anything.
Just grab the duration of the lives. Really?
Yeah. The judge does have some wiggle room on that, but I don't see any reason why it shouldn't be lifetime. Do you?
No. Do you mind when she comes up if I go to this with
No,
her?
I don't mind.
Okay. Yeah, it'll be nice to hear. And we're gonna dismiss the misdemeanor whenever she gets sentenced, right?
I don't know that was
Double
part
check,
of her
double check
deal.
your
Okay.
records. I'm almost positive it was. It's somewhere. Of course, everything I do is oral.
Well, everything I do is in writing, so.
It's not a huge issue. She's been in jail a long time. Yeah, I feel, hopefully there's, I gotta get better about conversation and handling somebody, because I know you guys are super triple busy.
What, me? No.
No, yeah, yeah. Oh, so close on Montanez yesterday. I was at 10 and with Courtney was at 12. I just, that guy's.
He is so dumb.
He's such a pain. Yes. And you know, his little wife is not really, I don't understand why she stays with him. She really sort of has some, well, other than being with him. You know what I mean? It's gotta be some kind of battered women's psychological thing.
thought it was.
Okay,
It's on
I
there.
was just fixing something within my email. Okay, good, thank you for. checking
Yep.
that out. Oh, it's on the plea form?
Mhm.
Okay.
It's on the
perfect.
plea bargain agreement.
Awesome, thank you. Yes, sir.
I'm gonna see part of.
Yeah, Ally, I'm all for,
I never was. No, you mean they're not so obvious for you to see?
I'm not stepping in that one.
I still don't know where they all are.
It's got the mom to testify, but the mom was actually gonna pay $4,000. All the state agencies sort of got together, there's 3 of them, housing, something else, yeah.
So she's really there.
This, it's a group. And, yes, other than. So the same way. Engineer or something, you know what I mean? And she's doing well. It's only one. It's like the struggle. God, her girl's been in jail. So the purpose of this adjustment was just to talk about what happened and how oh, I'm sorry. Okay. We're about fine court costs, all this probation fees, none of that nonsense. You're just trying to protect. So the purpose of maybe this is a question of probation. Yes, psychologically. That might not be a bad idea. I just don't want it to interfere with their ability to. You know what I mean? I mean, in other words. Through all the discovery stuff, I just.
That was part of it.
All right. Pardon the delay. Maybe seated. Come on up, Miss Buse. Pardon the delay.
I've got Frank Hernandez on your docket. I'm actually asking the court to withdraw.
Is Mr. Hernandez here?
Yes, Your Honor.
Come on up, Mr. Hernandez. What's our issue here?
We're just can't communicate, Your Honor.
Are you not communicating with your attorney? Why?
Just trying to figure out things back and forth between each other.
Well, that's not an answer, really.
Yeah.
I mean, she's here to represent you. Are you, when she's asking you for information, are you not providing it? I mean, what I'm asking is what's going to be different with the next person?
I think the county-wise is the best thing too, because she's all the way in Travis right now, so it's kind of getting the communication on
There's also a financial issue.
financial.
What is the setting on this case?
This is our second pretrial setting.
Why are we just on a second pretrial setting when on a case that was indicted? Becky, do you know why we're on a case that was indicted 18 months ago? We're only on a second pretrial?
A warrant was issued at time of indictment and it wasn't executed until April.
That's a good answer. So what are you going to do if she's not your attorney?
Trying to get a court-appointed attorney right now.
Okay, have you gone and filled out the court-appointed attorney form?
I'll send you the after this.
And you can't represent him?
No.
Right. Go downstairs, please, and fill out that form. The deputy will indicate where you need to go. You need to come back to court. Okay, after you do that, the deputy will send you that way.
Maybe excuse Your Honor.
So he did fill out an application back in May. I'm not sure if anything has changed.
Has anything changed in May since you filled out the application?
No.
Okay. And he was denied at that point? Okay, if you just take a step back, we're going to get together an order for you. We don't need to do the reset on it yet, so we're gonna talk to him. 20 days. How you doing, Mr. Darwin?
Good, Your Honor.
Can we get your client, please? Is that Mr. Chrysler?
That is correct.
How are you doing?
I'm doing well.
How you doing, sir?
I'm doing all right. How are you?
Try 2 days. You're ready on July 29th. Then we had to proceed on a case that was set for custody. State, you ready?
Yes, Your Honor.
Vince,
Judge, I do have a motion to continue in for today.
do you have a copy of that for me?
Yes, sir.
If you're in trial, though, the feds will allow you to be here, right?
Not in Del Rio. It's not San Antonio. It's Judge Moses.
So I just want to be clear
Judge
that I
Counts.
understand the position of the judge is that if you are in trial, you have to leave your trial for the other person's court.
For Judge Moses's court, yes.
And why is that? What's the difference?
Because she says that she has the supremacy clause in the US Constitution.
Oh, yeah.
I just, that's what she says.
Okay.
So next week's a really bad week with all those settings, Judge. Normally I just have like 1 day, but I have 3 days next week.
The attorney will explain to you what this means.
Thank you.
Okay.
Yes, sir.
Thanks. How you doing?
Your Honor, may I reapproach?
Yes.
Your Honor, I've had an amended filing presented to the court. I've also included Ms. Booker's letter to the court that should be coming in on the case.
Have you had the opportunity to review this, State?
I have.
Do you have any argument?
No, Your Honor. State is ready, but defers to the court.
Should be ready, sir. Yes, Your Honor. Thank you.
Let's see for Mr. Rubio.
Rubio, Mr. Rubio, come forward, please. You ready on Hart?
Yes, Your Honor.
How you doing, sir?
Sorry about the orange this morning.
Rubio, you ready? Yes, sir. Court calls CR 233819F, the state of Texas versus Carlos Rubio. Can counsel please make their announcements for the record?
Allison Boost for the state.
Anthony Mendoza for defense.
And are you the same Carlos Rubio who pleaded guilty to possession of marijuana, 50 pounds or more, or 50 pounds or less, but more than 5 pounds?
Yes, sir.
You raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
All right, we're here today for your sentencing. I have received a pre-sentence investigation report from probation. Counsel, have you had the opportunity to review that report and discuss it with your client?
Yes, Your Honor.
Are there any corrections or modifications?
No.
Is there any legal reason we can't proceed to sentencing?
No, Your Honor.
State, any argument?
No, Your Honor.
Defense?
None.
So here's my concern on your case, Mr. Rubio. What I read was you needed money, so you were going to sell, that's what it says, a lot of marijuana and make a quick buck.
Yes.
What's going to be different now if I follow this plea agreement in the future, and that you need money again and it doesn't go back to dealing drugs?
I'm not gonna do that again, Your Honor. I mean, I promised my son, my sister, my dad, they need me more, and I'm just helping them out with everything right now.
So it sounds like you have a reason to do better.
Yes, sir.
And what's that?
Well, my family, I mean, they're more important than doing anything and having to sit in jail for something done, so.
Yeah, I think so. We'll do, I'm gonna give you that opportunity, then make sure that you're doing what you need to do so that you can take care of that family.
Yes, Your Honor.
If I give you this opportunity, will you take advantage of it?
Yes, Your Honor.
Okay, good. I'm excited about that. The court, having found there was sufficient evidence to substantiate your guilt, I do not find you guilty at this time. I grant your application for deferred adjudication. That will be for 8 years. There will be $1,000 fine. There are court costs that are due today. You will pay restitution, your monthly fee, and there will be 250 hours of community service restitution. You will do the drug offender education program, pay all restitution that is necessary. You will do frequent random UAs, the moral recognition therapy class. And do you have a job?
No, right now I've been helping my father and my sister with everything. My father's diabetic, and he had half his foot amputated, and then got 3 toes amputated like 2 months ago.
So how are you paying for things?
Well, my sister, she owns her own business, and I help her every now and then, but she has cancer as well. So, I mean, I just helping her with her work, whatever she gets. And my father's been paying for his stuff. I just drive him around. And then, like I said, luckily I have a huge family. So I have 2 brothers that are also helping me.
Okay, can you, so is it time that you can start looking for a job?
Yes. I mean, now that things have gotten better, I mean, because one of my brothers passed away, and we were going through an eviction with his wife, and it was just real messy. And now she's gone now, and things have, like I said, calmed down a little bit. My father's not going stressing out as much as he was before when she was around. So he's not having to go to the hospital like every other week lately. So
part of this supporting your family is, I mean, not doing it through dealing drugs, but rather going and getting jobs. What I'm going to do is have you register with the Texas Workforce Commission. Okay.
Okay.
And what I want you to show is that you are making applications at least 3 per week.
Okay.
You need to provide proof of that.
Okay.
All right. Let's not be testing dirty on any drugs, because then you'll be spending money on things you shouldn't.
Yes, sir.
All right. Is that a deal?
Yes, sir.
All right. I want to see you be successful. Probation is here to help you out in that area.
Thank you.
All right. Good luck to you. Is there anything else we need to take up?
I have a quick question. Do we have court opinion attorney fees assessed in this matter?
We do, Judge. I don't have the voucher submitted just yet. I will get that submitted as soon as possible. He also lives in Fort Bend, Judge, and I've already spoke probation. Mr. Rubio is aware it will be transferred, but to still check in with Hayes whenever he needs to, and as ordered.
Okay. They'll handle that transfer. All right, sir, I followed your plea bargain agreement, and because I followed your agreement, you do not have a right of appeal, and I'm signing the trial court certification. Good luck to you, sir.
Thank
you. No. Sorry. Okay. Nathaniel Ramirez, sir.
Yes, you tested clean?
I believe so.
He did.
Okay.
Okay, so.
Want to come up, Judge?
Come on up.
Danny.
Mr. Ramirez. You told me you were gonna be cleaning your work. Good for you. All right, let's keep that up. All right. What we're gonna do is just reset your case on another pretrial setting. When you come back, we're gonna test you again.
Yeah,
right?
yeah, I get tested every week last year.
You are?
Yeah.
Okay.
that
Is she helpful?
Yeah, to be honest, just was scared of prison and trying to, like, I'm young and I was trying to be honest, have fun before I go. But I mean, wasn't hopeful at the beginning, and now I need to have a better mindset. He's told me, and the private investigator told me, just need to have a better mindset and
That's true.
not stay away from
It's
it.
up to you, right?
Yeah, it is up to me, and I haven't been sober in so long. I feel weird and different. I'm trying to get mental health to help.
Yeah, good.
And Judge, part of the asking for the pre-trial is that he has 2 psychological evaluations coming up September 26th and October 3rd. That's why I was asking for the pre-trial, so we can get those done. And I can provide
We'll do
information.
that. Well, one of the things that you can already start doing, if you're talking about being sober, is start going to NA or AA meetings. Have you been to one of those?
No, I haven't been to one of those. I never had a drug. Well, this probably gotta admit to myself, I have maybe a little bit of a problem, but I never really, it hasn't affected my life in a bad way. I just, maybe depression and weird thoughts. Maybe I need to go back on medication, because I was on it before I stopped, when I became an adult. And it was for juvenile services, stopped and mainly pivoted towards marijuana. Never no chemical drugs. It was mainly marijuana. Dabbled in antidepressants.
Well, what we know is that some drugs make those sort of mental health issues worse, right? And so we want to keep you clean, and that will be helpful to you. You don't have to. I'm not ordering it.
No,
but
I'm gonna be clean.
No, you have to be clean.
Yeah.
But what I'm not ordering is that you go to NA and AA, but those programs are very helpful. There's one all around us, okay? Maybe that's something to consider, is you can go in and you can start talking to those people. It's one of the best programs that we know to help people in your situation. So maybe you can just consider it, and if you come back and you tell me that you're doing it, I'm gonna be impressed. All right?
All right.
All right, good luck.
Thank you, Judge, for the excuse.
Good night. Hello, who do you have?
I have Pierre Hill Jr., and he needs to be arraigned on these charges, Your Honor.
All right, come on up, sir.
Oh, yes. Speak up, okay?
How you doing?
I'm good, yourself?
Good. You want to be arraigned rather than a waiver? Is that right?
Yes, sir.
Very good. According to the indictment for me in CR 2240F, in the name and by the authority of the state of Texas, a grand jury for Hays County, Texas presents to the 453rd District Court of Hays County, Texas, the following charge. Count 1, theft of firearm. On or about the 9th day of May 2024 in Hays County, Texas, the defendant, Pierre Jamil Hale Jr., did then and there unlawfully appropriate by acquiring or otherwise exercising control over property, to wit, a firearm, from Cheyenne Ceballos, the owner thereof, without the effective consent of the owner and with intent to deprive the owner of the property. Count 2, theft, $30,000 to $150,000. On or about the 9th day of May 2024 in Hays County, Texas, the defendant, Pierre Jamil Hill Jr., did then and there unlawfully appropriate by acquiring or otherwise exercising control over property, to wit, an automobile of the value of $30,000 or more, but less than $150,000 from Cheyenne Ceballos, the owner thereof, without the effective consent of the owner and with intent to deprive the owner of the property. That is signed by the foreperson and is against the peace and dignity of the state. To those charges, how do you plead?
At this time, we enter a plea not guilty, Your Honor.
Sir? Guilty or not guilty?
Not guilty.
Very good. I will enter that into the criminal docket. Your next setting will be a pretrial setting. Thank you. Thank you, Mr. Brown.
Welcome, Your Honor. And the excuse.
You may.
Fire.
Mayor.
Yes.
Coach, for the third time, Your Honor.
Yes.
I'm trying to make sure that this doesn't happen again and getting all of my pieces on the same page. I know for a fact that I'm trying a continuous sexual abuse of a child in Travis County on November 4th. And on November 18th, they're trying a double manslaughter in Williamson County in 277. And so with the court's permission, may I have that December 2nd setting? The only reason I mention this, Your Honor, is because the double manslaughter, Judge Matthews said, no motions for continuance will be considered or granted. It's got to go because there are international witnesses. Thank you, Your Honor.
Hello, Mr. Evans. Who do you have?
Good morning, Your Honor. I have Mr. Jerome. He's up in the courtroom.
Come on up, sir.
First of all, Your Honor, before you brought up, I object to any live streaming or recording going on in this courtroom. I don't consent to it on my behalf or on my client's behalf.
What's your legal basis?
I do not consent. My understanding is the local rules of Hays County have been revamped and that you now follow, or that you now have incorporated the Rule 18C of the Code of the Rules of Civil Procedure, Your Honor. I flat out don't consent. I object. This is not the proper place. These courtrooms are open and accessible to the public. There are ramifications of putting these matters on recordings that go out on the interwebs and can be repurposed, re-edited, repackaged however you want. I don't see any reason to bring any particular attention to these criminal cases before the court's docket. It is a distraction. I object.
Very well. Your objection is noted. Can you come forward?
I
please,
want a
Mr.
ruling
Jordan?
on my objection, sir.
Okay. Well, it's noted.
I would like to have a ruling. You have noted my objection, but I'm asking you for a ruling. Is it sustained or is it overruled?
Well, what, do you have a motion? And you don't have anything before the court.
Well, often, Your Honor, I object during the course of a trial. That doesn't mean I have a written motion in hand.
Well, you can put a motion together.
And when I make an objection on the record and ask for a ruling, that's all I'm asking for, overruled
Okay,
or
well,
sustained.
I mean, there's not an objection. You can make a motion in this. I mean, it's obviously that I'm going to move forward, so it's overruled. Okay. But if you want to make a motion, I will consider your motion.
So for the record, the oral.
We're not on the record. Do you want a record?
Yes, I would.
Court call CR 24-2113F, the state of Texas versus Jose Duran. Counsel, please make your announcements for the record.
Allison Boost for the state.
Paul Evans on behalf of Mr. Jerome.
The floor is yours, sir.
Your Honor, I understand that these proceedings are being live streamed. I don't know where they're being live streamed to. The court has not provided me with the courtesy of letting me know what website these are on. However, I do object to being recorded in open court. I do reject to these being live streamed. I believe that there might be incalculable downstream effects to this, including possibly witnesses who have some knowledge of the matters before the court, watching these proceedings on YouTube or Snapchat or TikTok or wherever it's being broadcast on, and perhaps their potential future testimony being altered or perhaps changed by some of those proceedings. There's also the potential for jury panel poisoning or problems there that could be easily avoided if these folks hadn't had the luck to be seeing these proceedings on whatever channel they were tuning into on a particular day. I object.
And what is the legal authority for your objection?
Well, Your Honor, it is my understanding that the local rules of Hays County have been amended so that we now follow Rule 18C of the Texas Code of Criminal Procedure, which spells out.
Pardon me, let's just make it clear. It's not of the Code of Criminal Procedure, it's the Code of Civil Procedure.
My apologies. I misspoke, Your Honor. Perhaps it should be in the Code of Criminal Procedure, which is exactly why I am making this objection and trying to make a record of this, Your Honor. But like I was saying before I was interrupted, it's my understanding that local rules of Hays County have adopted 18C from the Code of Civil Procedure. And that provision spells out that if any party does not consent to being recorded in court, then the recording does not occur. I am not consenting to being recorded in court. I find it personally very offensive for someone to record, videotape, or take pictures of me without my consent. I find that offensive on a very personal and very cellular level. That is why I'm objecting.
You see that camera up there in the corner? In the back corner?
Allow me to put on my eyeglasses, sir.
Very well. That has been recording you for the last
Yes, sir, but it's
10
not
years.
broadcast on YouTube as part of activities.
I'm just responding to the offense that you feel on a cellular level to being recorded. And I want to make it clear that all over the courthouse, when you walk through, there are recordings going on. And as to 18C of the Code of Civil Procedure, I am the person who put that into the local rules because I recognize that it is there. There is no similar rule in the Code of Criminal Procedure.
And yet you are continuing to record and live stream me without my consent.
I am recording and live streaming the proceedings in a public courtroom. Yes, I am. You have chosen to participate in this public courtroom, and I appreciate that. You're a fine attorney who does a good job for his clients.
I don't
And
need the
so
plaudits, sir.
And and therefore you are part of this proceeding, which is being recorded and live streamed. Very well. Let's take up Mr. Duran's case. All right, we're here on a pretrial setting. Defense, do you have an offer?
I have, Your Honor. I am in receipt of it as of, I believe, late last week. I would like another pretrial setting so that me and my client can intelligently discuss that offer.
Very well. Do you have discovery?
I do. There's a one hiccup with one of the videos. I think it's covered in all of the other videos. I will be addressing that with the state between now and the next.
Very good. State, are you aware of what it is that you need to get to the defense?
I am not.
It's just a tiny little hiccup. I'll send you an email.
Okay.
So is this something that you think that we can get resolved before the next setting?
Yes, sir.
All right, so your next setting will be another pretrial setting. We will move at some point into the future to a plea setting, but we're not quite ready there yet. That way your attorney can get all the information from the state and make a decision of how to recommend to you how to move forward, okay?
When's my next court date?
I'll let you know here in a second, my brother.
The coordinator will let us know. All right?
Yes, sir.
Thank you, sir. Thank you, Mr. Evans. Have a good day. Or do you have more?
I have Mr. Hernandez also on the pretrial docket, Your Honor. I'm asking to move that to a plea docket 6 weeks from now, if we could.
Mr. Hernandez, can you please approach?
He's in
He's
custody.
in custody, Your Honor. I very strenuously object to putting that case on camera, Your Honor.
Okay, well, we're not going to call out anything about it, but he has a right to be in court and hear the proceedings.
And he has a right to not consent to being recorded. And on his behalf, I'm telling you, we're not consenting to that.
Okay, please bring him up.
I am working on a plea out of Judge Tibby's court. The client is in custody. I'm lawyer number 4. I've been trying to get that case resolved for 4 years. I'll be back once I get that plea finished.
Thank you, Mr. Evans.
I did, two cases. I'll start with the one we're probably less familiar with, which is Brandon Vasquez.
Vasquez, okay, Mr. Vasquez, can you approach, please?
That's what I want to get to. He's not present. I received the
Oh, yeah, that
email.
case has been transferred.
Oh, it has.
Yes, it's no longer in this court.
There was a co-defendant with a lower cause number that was in the 22nd, so it just got moved to be with the co-defendant case.
Okay, that's fine. I was gonna say he's in a inpatient rehab anyway. So
okay.
We're not here. And then that would be Jordan Coombs is my remaining.
Okay, Mr. You see my screen.
He's indicating yes, John.
Why were you not here yesterday?
Correspondence with Mr. Coombs.
What's
That's
that?
his writing at the bottom.
Is that accurate?
It's from him, yes.
I mean, do we? Is it,
Notice was sent to the attorney.
okay, so we're gonna tell him today what the next date is, though. What is the setting?
Oh, he filed a waiver of arraignment this morning.
Yes, Judge, first contact I've been able to have with him, he just says he did not get anything in the mail, or he didn't know he had to be here that particular day. And says he's not gonna have that problem again.
Very good.
Continue to write.
State, so you know, he said he didn't get notice yesterday. Okay, we are set for a motion to revoke. Is there any agreement on that motion?
Defense counsel's received offers on it. I don't know that he's had a chance to talk to his client about it.
I've spoken to him this morning, and we could talk about it more and work on a possible counter offer.
Okay, well then what that says to me that it is contested, and therefore we are going to set it for a contested hearing at the date given to you by the court coordinator. If you reach an agreement prior to that date, then we will have you, you can come back in so that it's not contested. The state doesn't have to bring in their witnesses.
Absolutely.
Okay. All right. So we will have a contested hearing on your motion to revoke at the date given to you by the court coordinator. You must be here for that hearing. I asked him if he understood, and he said yes. So we will come back. If y'all need a date before then to reach a resolution, I'm happy to give it to you.
Yes, sir.
All right.
And I've also indicated with him he's got texting functions on his phone, and he's agreed that's the way for him to reach me and to be reached.
We had interpreters, signed interpreters for you here yesterday.
Number a pendant. This one died always at the last second. Here you go. I'm sorry, sir. I just didn't know that I have court yesterday.
I understand you will get your next court setting right now, okay? Okay.
Thank you, Judge.
Very good, yes.
Judge, before we move on, I don't see Mr. Courtney here. I understood we were going to start at 11:15.
I think we need to do Anya first though, don't we?
We do, but I do have 2 out-of-county witnesses who are waiting on that if we're not going to get to it today, which it doesn't look like we
All right,
will.
we can get started.
Okay.
All right. Mr. Hardaway, come on up.
Yes, sir, Judge, I'm here on
I'm sorry.
Lazaro, Gonzalez, Espinosa,
You're on
Mr. Thompson.
Hardaway's case, yes.
Yes, sir.
I
It's
was
sentencing.
thinking what I saw in here.
No, absolutely, Judge, absolutely. There are worse things you can call me. But yeah, if the court's ready, I think that the state has a judgment prepared for Lazaro, Gonzalez, Espinosa.
Okay.
We would like to be heard on conditions of probation briefly, Judge. But
course.
obviously, you'll take a look at the PSI and get up to speed. Minister Lazaro, or Minister Espinosa.
Yes. When was the last time he was tested?
I believe it was at the PSI, Judge, and it shows it was negative.
That's correct.
I had read this and that's why I went back to the defendant's version. Have you talked to him about that?
I have not, Judge. He read the statement. I just glanced through it this morning.
Yes, can you, because we need to take it up. I'm not sure that he is taking responsibility, and if he's not, then we can't go forward with the plea. So if you talk that over with him.
No, briefly. Yes,
Okay.
sir, Judge.
All right.
No,
Yeah, they have one for you.
PSI.
Anyone else ready? Yes.
Hi, Judge.
Hi.
I'm Courtney Stump. I don't think I've
Hi, Courtney.
been
Nice
able to meet you yet.
I'm Tanner. Tell me your last name.
Stump, like a tree stump.
Okay.
Yes, I get all the
Nice
short
to meet you.
jokes.
Thank you for your patience today.
Yeah, no worries. I have a plea that should be ready. It's with Mr. Miles Williams. It's
Okay.
on your docket today.
All right, let's do it.
And you'll want to stand in the middle,
Sorry.
just so there's microphones. No worries.
Can we get Anya Hart, please? Okay. Mr. Green, what do you have?
Just a recent, Miss Robin.
Is she here?
She is, Judge.
Miss Medina? Miss Medina, can you go downstairs, please, and get a test through pretrial for me? Are you going to be clean?
She'll go downstairs and get a test.
Okay, are you going to be clean, man? Okay, you can go ahead and go downstairs. All right. On, tell me last name.
Williams.
Williams. Ruby, are you ready?
Yes, sir.
Court calls CR 24-1815F, the state of Texas versus Miles Williams. Can counsel please make their announcements for the record?
Allison Boost for the state.
And Courtney Stump for Mr. Williams.
Are you the same Miles Williams who in CR 24-1815 is charged with deadly conduct, discharged firearm?
Yes, Your Honor.
Can you raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right. You can put your arm down. This is a third-degree felony that you are charged with. State, what is the range of punishment for that charge?
Not less than 2 years, no more than 10 years in the Texas Department of Criminal Justice, and a fine not to exceed $10,000.
Do you understand that that is the range of punishment that you face for this charge?
Yes, Your Honor.
I have paperwork before me that indicates that you would like to enter into a plea bargain agreement. I'm showing you what is the court's written admonishments, the waiver of rights, and the stipulation of evidence. Have you been through this packet with your attorney and discussed its contents?
Yes, Your Honor.
On page 4, there are a list of rights that you would be waiving if you entered into this plea bargain agreement. Did you know that you'd be waiving those rights?
Yes, Your Honor.
On page 5, there is a stipulation of evidence. I will use that to determine if there is sufficient or insufficient evidence to substantiate your guilt. Did you know that I would use it for that purpose?
Yes, sir.
And is this your signature on the final page?
Yes, sir.
Sir, this is an agreement between you and the state. I don't have to follow this agreement, but if I don't, I'll allow you to withdraw your plea and you can proceed as if this didn't happen. Understood?
Yes, sir. Yes, Your Honor.
You don't have to plea at all. You have a constitutional right to go to trial. You have the right to remain silent during that trial. And you have the right to have your attorney cross-examine any witnesses that the state brings against you. Do you understand those rights?
Yes, Your Honor.
Understanding those rights, do you still wish to proceed with this plea agreement?
Yes, Your Honor.
Are you a citizen of the United States?
Yes, sir.
If not, a plea in a case like this could have serious consequences. Counsel, I have before me the discovery compliance statement regarding the state's obligation to give you discovery under Article 3914. Are you satisfied the state fulfilled that obligation?
Yes, Judge.
And do you believe that Mr. Williams is competent to enter into this plea?
Yes, Judge.
The reason I ask about the evidence is because you have the right to know the evidence against you. Did you discuss that evidence with your attorney?
Yes, sir. Yes, sir.
And do you believe your attorney has provided you with effective assistance of counsel during the course of this case?
Yes, Your Honor.
According to your plea bargain agreement, in exchange for your plea of guilty to deadly conduct, discharged firearm, the state will recommend 10 years in the Texas Department of Criminal Justice. That would be suspended for 7 years. There would be a fine, a fee, an evaluation, community service, and you would forfeit the weapon. Is that your understanding of the agreement?
Yes, Your Honor.
Would you like to enter into that agreement now?
Yes, Your Honor.
To the charge of deadly conduct, discharged firearm, how do you plead?
I plead guilty.
Are you pleading guilty? Because you are guilty and for no other reason.
Yes, Your Honor.
Based on your plea of guilty, based on the stipulation of evidence, I find that there is sufficient evidence to substantiate your guilt, find that you are guilty. What I'm going to do is order a PSI. That means someone from probation will talk to you. They will prepare a report for me. And after I receive that report, we'll come back and do your sentencing at a future date. Understand?
Yes, Your Honor.
All right, very good. Make sure you're cooperating with the probation officer.
Yes, sir.
Thank you.
Thank you, Judge.
Yep. All right, we ready?
I think so, Judge, if I may.
So we'll do that. We need to put it on the record.
Yeah, no.
Are you ready to answer those questions?
I believe so, Judge, yes. I was just gonna make a record if that's okay with the court.
Oh, yeah.
And
It's
ask him.
Lazaro, Gonzalez, Espinosa.
Let me get to that point.
No, absolutely, go ahead, Judge.
Ready, Ruby? Yes. Okay. report called CR 23-5233F, the state of Texas versus Lazaro, Gonzalez, Espinosa. Can council please make their announcements for the record?
Allison Boost for the state.
Trey Thompson for Mr. Gonzalez Espinosa.
And are you the same Lazaro Gonzalez Espinosa, who in CR 23-5233F is charged with, in count 1, unlawfully carrying a weapon on prohibited premises, and count 2, aggravated assault with a deadly weapon?
Yes, Your Honor.
Can you raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, we're here today for your sentencing. I have received a pre-sentence investigation report from probation. Counsel, have you had the opportunity to review that report and discuss it with your client?
We have this morning, Your Honor, yes.
Are there any modifications or corrections?
We would like to make a clarification if we may, Your Honor.
Yes?
This is pertaining to the supplemental information, specifically the defendant's version. If I may make a record by asking some questions of Mr. Gonzalez Espinosa.
You may. Sir, you're under oath.
Oh, okay, Lazaro. We've discussed this case at length, both the plea negotiations as well as the evidence that the state of Texas has in this case.
Yes.
And you got to make sure and answer verbally, yes or no.
Yes.
Okay, let me ask you, in your version of events that you spoke to probation about, you admitted that you had been drinking that night and you were in fact intoxicated.
Correct, yes.
How clearly do you remember the events of that evening?
Not clear at all.
Okay, now we've talked about the discovery in this case, the evidence that the state has.
Yes.
And you're aware that there were multiple witness statements that were provided. Is that
Yes.
correct? You're aware that there were 911 calls that were recorded.
Yes.
And I've listened to those and reviewed those and talked about those with you.
Yes.
And are you aware that there are events that are depicted that kind of conflict? There are people who say that you pulled the gun out inside the bar
Yes.
and pointed it at one of the patrons or one of the bartenders.
Yes.
There are people who said you pulled the gun out outside of the bar.
Yes.
And do you have a recollection about which one of those is accurate?
I do not.
But we've discussed that the closed circuit surveillance, the video from inside the bar shows you with the gun, but does not show you pointing the gun at anybody.
Yes.
Do you dispute that there may be evidence that could convince a jury beyond a reasonable doubt that you may have aimed a gun at one of the bartenders outside of the bar, outside of the field of view of the video?
I do not.
And are you pleading guilty and accepting the plea bargain from the state because you feel like you are guilty and there is evidence that would convince a jury of that fact?
Yes.
Now, when it comes to your time here in court, you are aware that this case has been passed around to multiple prosecutors.
Yes.
And were you aware about a conversation that I had with one of the prosecutors for the state of Texas who indicated that they were not long for this office?
They were what?
They were not long for this office, that they were about to quit or go to another job?
Yes, I'm aware.
And are you aware, or did I tell you that that prosecutor told me they would not be contacting any of the witnesses or the victims in this case because of that fact?
Yes.
And does that make you feel like you didn't get a fair shot necessarily with the Hays County District Attorney's Office? If you feel that way, just tell the court, Lazaro.
Yes, I do feel that way.
Nevertheless, are you here accepting this plea bargain and wanting to move forward?
Yes, I'll accept.
Would you like the court to accept the plea bargain and to impose punishment?
Yes, I would like to.
Okay, Judge, I'll pass the witness.
State.
No questions.
So I just want to confirm, you understand that the cases that you are pleading to are unlawfully carrying a weapon on prohibited premises. Do you accept responsibility for that charge?
Yes, Your Honor.
And the second is for aggravated assault with a deadly weapon. Are you accepting responsibility for that charge?
Yes, Your Honor.
Okay. Is there any legal reason we can't proceed to sentencing at this time?
Subject to the conversation I'd like to have with the court about the conditions of probation, no, Judge.
Yeah.
No reason from the state.
Argument from the state?
Just ask that you follow the plea bargain, Judge.
Defense?
Judge, we would ask that you follow the plea bargain as it pertains to the kind of overarching conditions, the length, the agreement not to oppose early termination. We would like to bring up with the court 2 conditions that have been recommended in the PSI. Specifically, if I may, one is the recommendation that the court impose jail time as a condition of probation, and I'll get to that one. The second condition is the recommendation that the court impose an interlock on Mr. Gonzalez Espinosa's vehicle. With respect to that one, Judge, we would ask of the court, if you are going to impose any sort of alcohol monitoring, that it be the in-home unit. Mr. Gonzalez Espinosa works using a company vehicle that is utilized by multiple people, and having the ignition interlock on that vehicle I don't think would accomplish what the court would be seeking to accomplish vis-a-vis Mr. Gonzalez Espinosa, simply because other people are going to be using that vehicle. Obviously, with the in-home, you can keep an eye on whether or not he's drinking. He's willing to do that, but we just don't think that the ignition interlock is feasible under the circumstances, and would ask the court, if you are going to impose some sort of alcohol monitoring device, so you do the in-home unit versus the ignition interlock. And then if the court's ready, I'll move on to the jail time.
Let me first ask, if there is an in-home unit, what will you be monitoring for?
Alcohol.
Right.
So like how often
How
do
will
we
you,
monitor?
yes, how will you be monitoring? Before you answer that, can you please identify yourself from the record?
Bailey Benson, Hays County Probation. So we monitor it 3 times a day. It goes off from 5 a.m. to 8 a.m., 5 p.m. to 8 p.m., 10 p.m. to 12 a.m. They have to blow into it 3 samples per day.
Okay. Do you understand that could be one of the conditions of your probation?
Can I?
Do you understand what she's
No, yes, I
saying
understand.
it is?
Yeah.
Okay. And your attorney is asking for that instead of having it on your company's vehicle?
Yes, sir. It's fine.
Okay. And you understand what it is, what you would be asked to do?
Yes, blowing it 3 times a day at those
Okay.
time frames.
Are you prepared to do that?
I'll make accommodations and I'll do it.
Okay. Next.
Obviously, Judge, we would rather that not be imposed, but if you are going to impose monitoring, we would ask for the in-home unit. The second issue that we would ask the court to take under consideration is the recommendation that you impose jail time as a condition of probation. First and foremost, Judge, Mr. Gonzalez Espinosa has given the court 20 years to hold over his head with respect to count 2. He's on probation for the next 10 years. You're going to have that at your leisure in the event he's unable to live up to the conditions of probation. Not only that, but he has a vested interest in being a model probationer in the hopes that this court would entertain allowing him to terminate early at the 5-year mark should the state find that he's in compliance with the conditions of probation. This is a first-time offender. He has agreed to be subject to supervision. He's talked to you today about his agreement to take on the in-home device. The only reason we didn't agree to everything that probation is recommending is just simply because the ignition interlock is not feasible given his particular circumstances. And in the jail time, Judge, obviously the court, the state, if they thought that confinement was appropriate for Mr. Gonzalez Espinosa, they had ample opportunity to make that recommendation. 3 separate prosecutors looked at this, and not one of them offered us prison time at all in this case. For a first-time offender who's agreeing to 10 years probation, I just think that adding jail time on top of that, given that the particular facts of this case, seems a bit heavy-handed, and I would ask the court to consider not imposing that jail time, Judge.
Okay, any other argument?
No, Your Honor.
Sir, having found that there was sufficient evidence to substantiate your guilt, I did not find you guilty. I'm going to grant your application for deferred adjudication. That will be for 10 years. It will be a $2,000 fine, a finding of a deadly weapon, $60 monthly supervision fee. You will do community service. Who is Blaine Barrel, Joel Reboyard, Riley McIntyre, Chad Trigg, or Emily Fernandez?
I only know Emily Fernandez.
Okay. All of those people, I'm assuming, were people that were at the location where this happened?
Yes.
Okay, so do you know who those people are? I mean,
I don't know the other 5, but I know the girl.
okay, if you see those people, do not go near them. All right. You must stay by that same token away from this salamander. That's on 301 North LBJ Drive in San Marcos. You must stay at least 500 feet away. So those are the other bars around it too. You're going to stay away from those, right?
Yeah.
Can't go to bars downtown San Marcos. And
just for, I hate to interrupt, but just for the record, we did discuss, Mr. Lazaro, that for the time that you're on probation, even just going to any bar,
yes,
could be a violation of the conditions of your probation.
Correct.
So specifically the blind salamander, but any bar or any place where alcohol or drugs are used or consumed.
And you also, it looks like the reason that a lot of this happened was because you were very intoxicated.
Correct, yes.
And so we need to do something to work on that. So I'm going to follow the request of your attorney. We're not going to put the ignition interlock on your work car, but you will do the in the home device. You will do an intensive outpatient program that will be followed by supportive aftercare. You will do random UAs. You have to do the cognitive education program class, and you will attend NA or AA at least twice per week. Have you ever been to one of those?
Yeah,
Okay, was it helpful?
it was helpful hearing the situation, but I stopped going.
Okay.
So I feel like that's gonna help.
Yeah, good. I think it will. It's one of the most effective programs. And you will take the anger intervention class. This request for jail, is there any reason for the jail request beyond what is the circumstances of this case?
No, Your Honor, I think it was just due to the instant offense.
Yeah, I mean, it's very serious. I mean, to get drunk and go hold up a gun at a bar is a concern. So we're going to be watching it close. There won't be any tolerance for any violations, and that means you could go to jail on those. You understand?
Yes, Your Honor.
All right, but this is your opportunity. So prove that it's right. Listen to your attorney. He's come in and negotiated a deal for you. It's a good deal, and you are going to avoid time. So please take care of yourself and use this as an opportunity.
Yes.
All right. I followed your plea bargain agreement. Because I followed your agreement, you do not have a right of appeal, and I'm signing the trial court certification. I also must let you know, you cannot possess any firearms while you're on probation. Do you understand that?
Yes.
Or ammunition, you can't have any of those.
Okay.
Understood?
Yes, yeah.
You had to think about that one. What were you thinking about?
Because I might have some lying around there. I need to throw them away.
That's right. You need to throw
Yeah.
them away. Because if someone were to come into your house and look and find those, that could be a violation.
Yes, sir.
All right. Thank you very much. Good luck to you, sir.
One more.
Your Honor, how long are we keeping the in-home on for?
Let's do 18 months and then let me know how he's doing. All right, good luck, sir.
We can ask, but we can object until the.
We're ready on Anya Hart. That? Oh yeah, we got all of this Cortez. I signed the waiver on Ignacio Munoz. How are you doing today, Ms. Hart?
I'm good.
Good, I'm happy to hear it. Going all right?
Yes, sir.
All right, good.
Judge, before we get started on this, I would ask the court to stop live streaming. The state intends to call a witness who is a peace officer who does
I want to give you notice of that there. Given what you see there before you, do you have any comment?
Judge, what is she set for today?
She said for a pretrial setting.
Well, obviously it's showing that she's positive for several things, correct?
That's right.
That's THC. I'd leave it up to the court. I'd have to look up what she's charged with. I apologize. Like what she's here on the pretrial.
It's possession control substance, Judge, and to give the broader context of what this charge is. Her niece was murdered, and through that investigation, there was a search for her house done where these drugs were found. She's since been as cooperative as she can possibly be with the Hays County DA's office in order to testify at the capital murder hearing, which is the end of next month. She recently, I think end of October or end of August, her cousin also passed away. So there's just been a lot of things going on in her life leading up to this moment. I'm her court-appointed attorney. She's indigent. She could not afford bail if this court was to revoke her bail and place her into custody, which would mean that the case just simply, she'd be in jail until this capital murder case is going to get resolved, which I don't know when that would be. So what I would ask the court to reset this a week, which would give her time to be clean from any methamphetamines that are in her system. Give her a UA a week from now, see whether or not she comes out positive or negative on that. If she comes out positive, she had her chance. The court can revoke her bond at that point. But this is her first felony. It's a possession charge of state jail. So I believe it would be mandatory probation. So eventually we're looking towards that as a resolution at the end.
Can you tell me what her current bond is? Right. Were you aware that you could not be using meth while you were on bond?
I was.
You were given a PR bond, which makes it to where there's very few consequences, but now there are going to be. Do you understand that? I understand that you're going through a very tough time, and the answer to that, though, can't be turning to methamphetamines and other drugs that are here. Your bond is currently set at how much?
It's $10,000.
$10,000, and it's a PR bond. That will become a cash surety bond. You will be taken into custody, and
if you may, Judge, could we do a $5,000 cash surety bond?
no, it was 10,000 is what they decided. And we can come back and discuss. She'll be getting clean this way.
Maybe we have a setting next week, then, Judge, we can reapproach.
We're going to be in trial next week, but we can do it at the next, we can do the fastest setting that we can get back. And you can decide if there's something you want to come forward on. All right. Okay, man.
Can I speak, please?
You may speak, of course you may.
It's going to be first, obviously, as your attorney, it's going to be against my advice, but if you want to say something, it's your prerogative, it's your right, okay? So that's the time.
The other is just that I'm talking about. I'm trying to get into the treatment for my neuropathy I was just diagnosed with. I'm already in the stage 3 of it. I just got in touch with some doctors in San Antonio. I was supposed to try to make an appointment to go and see them.
Is someone helping you with that?
No, I'm here by myself. I'm trying to deal with all of this with my niece passing and
okay, what I'm going to do is I'm going to assign pretrial services to you. Part of what they can do is help you make those contacts, and pretrial services can help you make those calls. But that gives you the opportunity. That's why Hays. No, hold on. Okay, you talk now. Go ahead.
I'm sorry. I just got my landlord to agree to let me stay in my house. And my car, I'm trying to make all my payments by tomorrow, so I don't lose my car and my housing. And
well,
I'll do anything else. I'll go to treatment or anything. You know.
Here's the problem: is that when you are using your money for meth,
I wasn't mine that I bought it. Somebody else got it, and I was just a poor decision that I made.
Okay. What I'm trying to get to is when you are using meth, you can't take care of those things. Someone from pretrial service, Hays County, has set up a great program where they are here before your trial to help you. You'll have a very good person assigned to you and they can start to work on those things. Once you are clean of methamphetamines, you have methamphetamines in your system right
I know, I
now.
did it on Friday because, and like I said, it was poor judgment.
So you know that's not possible. So now you're not being honest with me.
No, I did it all
No, you
night
didn't,
Friday. I did
because
quite a bit.
methamphetamines doesn't stay in your system that long.
I did talk to the pretrial officer. She confirmed that that's possible for it to be in the system.
It's 3 days.
She's already on pretrial, judge, and meth can stay like 3 to 5 days.
Okay, well, no, you're already on pretrial?
She's on pretrial.
Because she had that PR bond.
Well, then that tells me that that's not working.
It
Okay,
was one
at
mistake
any
I
rate,
made.
this is what we're going to do. And Lydia, if you would, please continue to help her. Thank you.
Yes.
You or her assigned officer. Okay. Thank you, ma'am. Mr. Hernandez, can you come forward, please?
She's still going into custody. That sounds like someone's wearing a I thought maybe he took it back, but. Yeah.
All right.
A quick question.
Yes.
I misunderstood you saying if yes, if anything's changed since May. But my job did change because I got court issues and I was traveling. So I did change jobs.
So are you making more or less?
Lesser pay. Because I'm not traveling no more doing that. So I am lesser pay now.
Or you have a job right now?
Yeah, yes, sir.
What is your job?
It's a roofing foreman, like a construction foreman for.
And where is that?
Here in Austin. In Austin.
Okay.
Or Austin, sorry.
Well, then, so you still want to seek?
Yes.
All right, well, then you have to go fill out that form.
Oh, I've been waiting for the officer to take.
Well, because I understood, you told me there was no change from the last time.
I know, I'm sorry about that.
That's okay.
Yeah.
No,
I
that's okay.
misunderstood the question,
Well,
that's why.
If I wasn't clear, I apologize to you.
Mhm.
So what we're gonna do is, he's gonna tell you where you need to go to fill out that form, and then you'll come back tomorrow at 9 AM and we'll discuss what we're gonna do.
Okay.
Okay?
Sounds
very good. Make sure you are here at 9 AM.
Thank you.
Do you need us for that, Judge, or tomorrow at 9?
Yes.
Yes, you do.
No, I don't.
Okay.
Yes.
We got William Baker. It's a writ of habeas corpus. I believe it's on the last page.
Okay, let me, State and Michaelowitz, yes. Let's talk about when we can do this for y'all.
Judge, can I at least cut my witnesses loose right now?
Yeah, and apologize for me. No, I don't like this. I don't like this at all.
I didn't hear my name, but I saw
Yeah.
burning
Yeah.
stare.
No, burning stare.
Right
It wasn't.
through my forehead.
I want y'all to figure out when we can do this. Obviously, we're not gonna get to it right now.
Yes, sir. Because I have work at 2:30.
Okay, well, you're gonna make work and he's gonna be able to go on.
It's important for me to have, keep having a job.
What's that?
It's just important for me to keep a job.
I agree.
Yeah.
I agree completely. And I don't want you to miss it. What's your job?
I got a job working at Home Depot. Right after.
Very good. Do you have skills in construction and those?
Yeah, I do. It's just kind of like it was in treatment, they taught us, get a job, get a better job, get a career.
Yeah.
So right now it's possible career too.
All right. Well, I like hearing that. Very good. All right.
If we can find a date, maybe designate an afternoon.
Yeah, right.
Like.
Yeah, I
Docket
didn't
I don't know.
Suspect that it would be
how the court does
of this. So
I did warn you yesterday. Today was going to be a day.
you did, but I didn't realize on this one. So what?
I'd listen to her in the future. She's good.
What is the timeline that you need to get those witnesses back?
Judge, I would ask for at least 3 weeks. My only scheduling issue is I am not here October 15th. Other than that, whenever the court has availability.
So you said 3 weeks window?
3-week window.
I'm not
What
here.
are we doing the week of October 7th and 8th? Jury trial?
But it's maybe Friday, Thursday or Friday.
Friday, October 4th. Oh, of the jury trial week?
Oh, I thought you 10th or 11th.
Okay.
The 7th is your trial week, Judge?
Yes. Well, then why don't we do it on the 10th in the afternoon?
It's fine. Perfect for me.
That'll work.
Okay, October 10th in the afternoon, let's set it for 1:30.
Do you want us here for docket in the morning?
No.
Okay.
You just have to, so you can work in the morning, we just need to, you only need to be here for your hearing.
Yes.
Okay? All right, October 10th. Thank you.
Appreciate it.
Baker, where is Baker?
I was hoping we could have him brought up. He's incarcerated.
Okay, let's bring out Mr. Baker.
And it, yes, sir, he is. It should be very brief. Mr. Rankin, I've been working very hard. We have a proposed order for you.
Okay. Let's see it.
You found somebody nicer to deal with than me, so.
Well, if I had known.
What is he charged with?
He is charged with what looks to be 2 keys potentially of, was it meth? Heroin. So it's gonna be a delivery case, or possession with intent to deliver. It's not indicted.
What's his current bond?
It's 150.
Y'all have agreed to this?
Go ahead.
I'm sorry, Mark.
No,
We
you go
agreed to a 75 cash surety, but Mark wants him, part of the pretrial release is he not leave his county of residence.
What is that county?
Kaufman.
Kaufman County.
Okay.
And I think take random UAs once a month and make sure that he's
We
not.
were gonna load him up with pretrial conditions. There was a curfew. I think we agreed to a GPS monitor.
Okay, let's put those, I'll put those together.
Yes, sir.
I think they did. I think they may have
I
already.
think
I
she's
have
ready.
it.
Are you ready?
I have it.
Okay.
I think we
And
already have
Mark,
it.
you said, monthly UAs?
Do we have
Yeah,
Baker
that's
on,
fine.
on his way up? Okay.
Yeah. Yeah,
So that's fine. The rest of
Okay. But you want them tested every month?
Yeah.
More hardship.
But they're not gonna do anything.
Right. Remember?
It's MARC.
They need to know what.
RNC.
The condition, do you, make sure we have his prescription on file? Does that need to be a condition?
Where did he get that, Oklahoma?
I don't know.
It doesn't need to be a condition. though,
He
right?
was telling me.
I hate 45 unless something changes.
He was telling me.
Or maybe.
We'll have it on file.
Yeah. after the- Okay. We'll be in touch because there's so much on all of those that we have to go through.
Sounds really interesting.
I mean, I guess drink it. You think maybe you just go to like one of those, like,
The vape shop thing?
yeah, I mean, I don't know. I mean, Oklahoma's closed, right? What's Kaufman? That's all I know. I don't want
Mr. Baker.
driving up and down that there.
Start all this confusion.
Yeah.
Allison, before I forget, if I assumed something inappropriately about that officer, please apologize for me.
I think that was literally the least of her concern.
You never know.
I think it was helpful for Anya to see the effects. It was helpful for me to see too. Because I would have been one of the officers clowning her like, yeah.
And it really, like, and Bennett is, I mean, excuse the language, but she's a hard ass. Like, I mean, I've seen people clock her, you know, when she's trying to arrest them, and she just keeps going. And so, like, she is not a whiner, she's not a complainer. So, when this came in, and she was like, no, it's serious.
It is too.
Knock on wood.
Just trying to earn a buck. Sometimes it makes me want like, maybe I'll sell some shit. I mean, I'm not ever going to, okay, Mark? I know. I'm never going to, I'm just kidding. Oh my God.
That's all right. Mr. Baker?
I'm so embarrassed right
Mr.
now.
Baker? Come on up, Mr. Baker. Mr. Baker, we're here on your attorney's motion to have your bond reduced. Your attorney has been here speaking with the state. They have come to an agreement on that both sides could be in agreement with appropriate result. We're going to reduce can make bond.
Yes, sir.
Understood?
Yes, sir.
So that is all that they've been working hard on you. I know you probably were expecting a hearing, but when we've gotten to this point, I'm satisfied with what they have. And so we don't even need that hearing.
Perfect.
Okay, so I'm going to grant that motion that has been put before me by your attorney. And make sure if you do make bond, that you do what and comply with the conditions that are on that pretrial services.
Yes, sir.
Okay,
Thanks, Alex.
Great.
Appreciate it.
Thank you very much.
Thank you, Judge.
Is there anything else you need to take up?
Sign this.
Yes.
Does he need to sign that?
Yeah.
Yeah, I signed yours.
Yes, sir.
Students, you'll come on up.
I'm gonna have you fill out a top portion. It's just your information. So whenever you do make bond, we have a profile for you.
Okay.
Okay. For pretrial.
So the reducing the bond is 75. Don't
Well-
worry about letting them know.
You got right over here. It's fine. So I will put out, it'll be probably later
Don't be
tonight,
running up
that I
and down
can
the
get to
road.
putting it out the
They
jury,
just want you to
the
call
journal,
the county at that
entry
location. You're
topics.
actually gonna
Make sure you get those
cover
done. I'll give
the
an extra day.
Don't mess with the
because it's on me
GPS. Don't be
first
running
thing
around
to see.
past 10 PM. So be in the house.
What'd you think? More questions
And
and
they're gonna
answers
want
now,
you
or?
to,
This- this is-
lab test now, or any of those private places.
Yeah.
I've told them.
Well,
about your
it's the court's
marijuana-
not what you expect
prescription
them to be.
marijuana for your pain, right?
These sorts of
So
things
obviously
are,
nothing other than that.
what's that?
Okay, that won't be a problem. will it?
No.
The biggest one.
I won't do that.
Do you have any questions?
Yeah, there's a lot
Main
going
thing
on,
is stay
right?
within Crawford
And
County.
you
They don't
guys
want
are gonna be a
running up
part
and
of
down
it,
the
right?
road.
And
Right.
you,
If you're gonna
as the
split
head
it,
of
come down
criminal
here for court
justice,
or whatnot.
future criminal
Right.
justice
Yeah.
He's for court, yeah.
participant, we're gonna need y'all to be good at this. So, thank you for being here. I'll get that to you and we'll talk about more questions
And
that
they're
you
not
have
gonna let you
later.
out until
All
they
right?
can monitor.
Have a
it.
great
The thing
afternoon.
is the monitor's free.
Yep.
That is good.
Yeah.
That'd be a tough one.